Ms. Twaku, can we just first call matter 17? Is it 17? No, 26.
Matter number 26, the matter of Abdian versus the landlord of the building premises, known as 15 County Street, Industrial West. Case number is 2023-074664.
May I please call my lady Jason down there appearing for Runcorp Proprietary Limited, who is the party that has been given notice to appear before the court in the matter, who is not the respondent in the matter. We have inquired about the applicant's presence here today, and unbeknownst, we're not sure who the applicant is or who the party is.
Charity Moteane, are you present? I'm loath to strike the matter, so I'm going to let the matter stand until 11:30, and we'll call it again then and see whether there's an appearance on behalf of the applicant.
As it is, God.
All right, then matter number 17 will stand. You may call, no, 26. Goodness, yes. All right, so you may call matter number 4 again.
Matter number 4, the matter of Sithole versus Media24 Holdings, Pty Ltd. Case number is 2023-070374.
My lady, I appear together with Ms. Goosen for the applicants.
Yes. Thank you.
My lady, may it please the court, together with Mr. Winks, I appear on behalf of Media24 and the journalists, the second to the 7th respondents that have been cited. And we are instructed by Philip de Klerk journalists.
Yes. Thank you. Mr. Berger?
Thank you, my lady. My lady, this case is not, as the respondents would have this court believe, about the applicants wanting to punish them by making an example of them in order to send a chilling message to other media and members of the public that they risk being called to urgent court. To suggest that it is, as the respondents have done, is to engage in mere conjecture and speculation. Instead, we submit this case is about the rights of two private individuals who happen to have been friends with the Deputy President for decades and once occupied senior positions in the Gauteng government in which he then served, not to be defamed. The applicant's plea to News24 and Netwerk 24 is simple. There is ordinarily no public interest in mentioning us as members of a so-called Alex Mafia in your reporting on the Deputy President. This case is also not about prior restraint, at least not in the sense contemplated by the key judgments on which the respondents rely. Print media, Mazetti, and MIDI TV. Instead, this case is about interdicting the respondents from repeating over and over again defamatory statements that they have made in publications that are not about the applicants, and statements that they intend to repeat over and over again until they lose interest in reporting on the Deputy President. In my main address today, my lady, I intend to deal with the following 5 topics in turn. First, the applicants' demands, as set out in their letters dated 6 and 10 July respectively, and the respondents' understanding of those demands. Second, the question of urgency. Third, the meaning of the term Alex Mafia as used in context. Fourth, the substantive merits of the application, with a particular focus on the applicant's prima facie right and the respondent's defense of protected comment. And finally, I'll deal with the proposed amendment to the notice of motion. If I can then start with the applicant's demands and the respondent's understanding of those demands. And the first document I wish to take the court to is the first letter of demand. This is Annexure FA8, which starts at page 01-93.
Can you just give me a second?
Sure. It's an annexure to the founding affidavit.
Not yet
Okay.
close to where you are, but I'm almost there. All right, so the page that you referred me to,
Is the case lines page.
Yes.
It's 01-93. This is annexure FA8 to the founding affidavit, and it's a letter of demand sent by the applicant's attorneys, Padayachi attorneys, on the 6th of July, 2023. And I wish to take the court to paragraph 9 of that letter, where the demands are set out. And the following is said: our clients have accordingly instructed us to demand, which we hereby do, in mitigation of the damages caused to our clients' dignity and reputation as a result of your publications, that you, 1, immediately desist from referring to our clients as the Alex Mafia, or that they form part of an illicit mob, and provide us with the necessary written undertaking by no later than 11:30 today, 6 July. And then secondly is a request dealing with the retraction of all references to the Alex Mafia or any illicit mob in your online and print publications. And then there are requests relating to further retractions and apologies. So that was the initial demand that was sent on the 6th of July. It was sent to Media24 and to the individual journalists who are respondents 2, 3, 4, 5, and 6. Those would be the editor-in-chief of News24 and 4 journalists who form part of the investigations team of News24. The first substantive response, there was a response which said that the attorneys needed to take instructions, and that came quite quickly, and that they weren't prepared to, in the circumstances, give us the undertaking within the short time frames. And then there was a substantive response which came on the 10th of July. And that is annexure FA11 to the founding affidavit, and that starts at page 01-103. And it's paragraph 6 that I wish to take the court to, where the following is said: under the circumstances, News24 is not prepared to comply with the demands made by your clients in paragraph 9 of your letter. Your letter sets out no basis for such a drastic infringement of our clients' constitutional right to freedom of expression, including freedom of the press. In line with News24's ethical obligations, your officers will be contacted in advance of any reportage which requires comment from them. So the key point I wish to make in reference to that paragraph is that there's a direct reference to paragraph 9 of the first letter, which were the 2 demands that I mentioned when dealing with annexure FA8. That was then followed by a second letter of demand, which was sent later that same day, being the 10th of July. Excuse me. That is annexure FA12 to the founding affidavit, starting at page 106. And it's quite a lengthy letter, but it ends, almost ends in paragraph 10.
sorry, this is now FA12.
FA12 starting at 01-106. And it's paragraph 10 that I wish to take you to, where we say, with this in mind, we would like to give your clients one last chance to respond positively to the substance of our clients' demands, and to do so by the close of business on Friday, 14 July 2023. Should an adequate response not be forthcoming, our clients will approach the High Court early next week for urgent interdictory relief, pending the outcome of their contemplated action for damages. The following day, there was another letter sent from the applicant's attorneys to the respondent's attorneys, essentially, excuse me, where they asked the respondent's attorneys to confirm whether they also acted for Netwerk für den Twinach and its editor. And then in paragraph, sorry, that letter, I don't know if I've given you the page reference. That's FA 13 starting at 01-112. That letter in paragraph 3 repeats the original demand that was set out in our letter of the 6th of July. So essentially extending the same demands to Netwerk für den Twinach in addition to News24. There are then two final letters in this set of correspondence that I wish to take the court to. The first is Annexure FA 15. That starts at page 01-119. And that is a response from the respondent's attorneys, from some of the respondents, from the attorneys representing all the respondents, but in this case, the response is specifically on behalf of News24, with a separate response in a separate letter on behalf of Netwerk für den Twinach. And in this response, I wish to take the court to just 3 paragraphs. The first is paragraph 3, where there is a mention of the term Alex Mafia and what the meaning ought to be, picking up on a claim that was made in our second letter of demand. If one then goes to paragraph 6 and 7 of the letter, one can see again the focus is primarily on the use of that term. And then in paragraph 7, excuse me, the respondent's attorney says as follows: News24 has, however, taken note of the concerns that your clients have raised and wants to emphasize that it will continue to use this term in its correct historical context. Of course, should new information come to light which puts your client's links with the Deputy President in a new light, News24 cannot be precluded from reporting and expressing opinions thereon as a result of this undertaking. Our understanding of that whatever the undertaking was, which we found difficult to understand, was that there was a commitment to continue the term and not undertaking to, if and when using the term, not to mention either the first or the second applicant. The second response was a response from Netwerk für den Twinach. That's Annexure FA 16, starting at page 01-123, and it's paragraph 5 that I wish to take the court to, where the letter says as follows: Netwerk für den Twinach takes note of your client's concerns regarding the potential abuse of the term Alex Mafia in future reportage. Insofar as our clients intend to report on Deputy President Paul Mashatile's current and historical links, and insofar as it may include one or more of your clients, due care will be taken to present the use of that term in its proper historical context. Again, understanding that the focus is on the use of the term Alex Mafia, and again we submit an undertaking that wasn't particularly clear as to how far it went and what it meant, and certainly wasn't the express undertaking that we had requested. So having looked at these letters, the point I wish to make is that by the time the application was launched, the applicants knew what the respondents knew what the applicants' key concerns were. I will come much later to deal with the issue of the amendment once I've dealt with the substantive merits. That then takes me to the question of urgency. And we submit that the key question to answer here is, why now? Much is made by the respondents in their answer and in their heads of argument that this term has been around for a long time. The publications that we complain about are publications that started back in 2007. They've identified a number of publications post that, and then there are a series of publications which I'll come to in a short while. This year. And really the question is, why now? Why is it now a concern for us? And I wish to answer that question by considering the applicant's chronology. Let me just ask my junior for a page reference, my lady. It starts at page 04-1158.
This is your
That's our chronology.
Yes.
So we start off dealing with the 1980s, and that's historical background. And then I want to go to the 2000s. And the first event, 31 August 2007, and that's the Mail and Guardian article that there is much talk about throughout the papers, entitled Mashatile and the Alex Mafia. And that's the article authored by the second respondent when he was a journalist at the Mail and Guardian. Then the next set of articles, one in 2009, the article in the 2010s or the 20-teens, not sure how one refers to that. Those are the articles that the respondents themselves identified in answer as the articles in which the term was used and the applicants, either one or both of the applicants' names were used in reference to the term in those articles.
So this is the 3 May one.
There's 3 May 2009, 18 August 2009, then moving to the next decade, 18 March 2011, over the page, 3 April 2012, and then 20 May 2014. And my lady, other than a second publication by the Mail and Guardian 4 years after its first, all of these articles are published by different media outlets. So they're the 2 Mail and Guardian articles, one in 2007, one in 2011. And then there's Sunday Times in 2009, Sowetan in 2009, Daily Maverick 2012, and ENCA in 2014. Then if we move to the next decade, we have 3 articles, or 3 publications. If you're not...
So the point you made, or perhaps just referred to, is the fact that all these articles are by different public
They're by different
houses.
publications, and they're quite spread out over many years.
Yes.
You'll see then, getting closer to the present date, but we're still 3 years back, a lone tweet published by a former mayor of Johannesburg. One can't say the former mayor because there have been plenty.
Quite a few.
In recent times. But this goes back 3 years, a single tweet. Then a News24 article in August of last year. Excuse me. Sorry, thanks, my junior's going to get some water. Apologies.
If you have a glass, then I have water.
Thank you. Thank you so much. Thank you. Really appreciate it. It's the coughing that might keep me brief today. There were 2 articles then towards the end of last year, and both of these articles were in the run-up to the ANC's National Executive Conference in December of last year. The first was a News24 article, second article authored by Mr. Basson, the second respondent.
Sorry, where are you now?
Oh, sorry.
Which,
now
what
I'm on
date?
the 22nd of August 2022.
Yes.
That's one of the articles that we identified as an article that
Yes,
was
that's
a
the
concern
one that
to
was
us.
published 11 months ago.
Yes. And then there's a second article by Daily Maverick, 10 and a half years after their first, and that's the 7th of December 2022. Then, as the chronology shows, Mr. Mashatile is elected, that's incorrect. He was at the conference in December, he was elected as the ANC's deputy president. On the 7th of March 2023, he becomes the deputy president of the country. So, sorry, that's an error on our chronology. And then the series of articles, a series of publications that take place and these are the ones that are highlighted, starting on the 6th of June 2023, going up to the 5th of July 2023. And these, the papers show, are all part of a special project that News24 has launched titled Mashatile Unmasked, a president in waiting inside his life of excess. And so after many years of an article here, an article there by different publications, at most two by any publication in particular, we then get the 26th June 2023 article. This is at the bottom of page 3 of our chronology. Then at the top of the next page, we get, also on that same day, the hosting of a podcast. About a week later, the publication of a podcast. And then we get, on the 5th of July, the open invitation titled Book Your Spot. News24 webinar delves into Paul Mashatile's inner circle and life of excess. Lady, what I wish to do now is to look at those publications in a little more detail. And here I wish to refer you to the founding affidavit, starting at paragraph 56. And this is on starting at page 01-27 of the bundle, where we start at paragraph 56, dealing with the first article of the series, the 26th of June article. And we mentioned...
What is the page number?
It's 01-27. And you'll see in paragraph 56, we talk about the article making two gratuitous references to the Alex Mafia, another reference to the first applicant as being the person who introduced Mr. Mashatile to a director of one company whose part owner, one of the alleged benefactors, acting through a second company, had, as part of a joint venture with a third entity, won a tender to build a diplomatic compound in New York City in 2016. And then we give a little bit more detail on the various references to Alex Mafia. And how it is, how it is used in the context of that particular article. And we say in paragraph 60 that the sting in the allegation is clear. Mr. Mashatile must have gained something from his friends having benefited from their relationships with him, and if we benefited, referring to the applicants, then our relationships with him must be corrupt. That is how the applicants understood the first article. Then we move on, and this is starting at paragraph 62. The which deals with the podcast of the 26th of June. And we say as follows, this is paragraph 62 of the founding affidavit. Not only does the podcast make numerous references to the Alex Mafia, but it expressly identifies Mr. Maile and me, as well as Mr. Kakana and Koza, as members that are associated with it. The four of us are described by Mr. Masondo as the people that have really formed the core of the Alex Mafia. Interestingly, Mr. Masondo also describes three of us as accomplished business people. It appears that in his view we don't owe everything to Mr. Mashatile. We explain a bit more of our concerns with that article, and then in paragraph 64, the deponent says as follows. The focus is on what Ms. Karim describes as Mr. Mashatile's dodgy business links and connections to dodgy people. And despite including the identified references to the Alex Mafia, the podcast mostly casts its attention on others, speculating about Mr. Mashatile's alleged benefactors and state capture 2.0. And as is the case with the other impugned publications, nothing new is said about the alleged mafiosi. Once again, we are just collateral damage. So what the founding affidavit is saying here is that here is this podcast which really isn't about us. It's primarily about other dodgy business links, other connections to allegedly dodgy people. It's not about us. It's about looking at the present, but we get mentioned and we get identified and thrown in, and essentially thrown under the bus as part of this exercise. The next publication we refer to, and the founding affidavit deals with in some detail, is the actual publication of the podcast, which took place about a week later. And paragraph 65 of the founding affidavit says as follows. The published version of the podcast goes further, making allegations that are not even contained in the transcript itself. As I've already noted, the publication of the podcast was accompanied by text that refers to corrupt business practices and Mr. Mashatile's connections with controversial tenderpreneurs. Most concerning is that we are directly implicated, given the promise to discuss his links to Edwin Sodi and the Alex Mafia gang. And what we see here for the first time is now, in addition to the use of the term Alex Mafia, it now gets at the end the word gang added onto that. And the title of the publication refers to mafia mobs. And so Alex Mafia, gang, mobs, all of these words thrown in together in a publication that identifies the applicants as members of the so-called Alex Mafia. Then the final publication that I wish to refer to now is the webinar invitation of the 5th of July 2023. And I think what's useful here is to actually read the invitation. And so what happened was, on the 5th of July, this invitation went out, an email invitation primarily, may have been published online as well, certainly to all subscribers. And it was an invitation to join a webinar that was taking place the following day, on the 6th of July. And if memory serves me correct, it was a webinar that was taking place at 12 noon, and if your ladyship remembers, the letter of demand was sent, included a demand for a response by 11:30, and so it was directly sought to get an undertaking prior to the webinar starting. Invitation. Lady, if you could just bear with me for one moment while I get the actual annexure. My lady, this is Annexure FA5. Is it 5? Starting at page 01-81. And the headline is Book Your Spot, News24 webinar delves into Paul Mashatile's inner circle and life of excess.
Wait a minute. 0185.
0181.
Yes.
Then the text is not very long, but I wish to read it in full. In a groundbreaking investigation titled Mashatile Unmasked, News24 shines the spotlight on opulent life led by Deputy President Paul Mashatile, whose connections with tenderpreneurs and wealthy associates have enabled him to sustain a luxurious lifestyle for years. Discover the intricate web of individuals behind Mashatile's life of excess, including undisclosed payments to romantic partners and luxurious stays. Notably, these lavish perks aren't registered in Mashatile's name, leaving questions about their origin and expenses unanswered. Join Peter Sithole, News24's assistant editor for investigations, as he hosts an engaging conversation with the journalists responsible for this expose. Nazara Karim, Sipho Masondo, and Carl Cowan will delve into Mashatile's connections with Saudi and the notorious Alex Mafia gang. News24 subscribers are invited to join this Match Watch webinar live on Thursday at 12 noon, 1200 hours. Sign up now to secure your spot. Yes, my lady, this is probably the most, or the article that the publication that the applicants were most concerned about. It talks interchangeably about Mr. Saudi and the members of the Alex Mafia. It makes wide-ranging allegations about this web of persons who are effectively keeping the Deputy President in his life, in a life of luxury, and draws no distinction between the applicants and Mr. Saudi, and ends with describing them as the notorious Alex Mafia gang. Now, it's correct, as my learned friends will point out and have the answering affidavit points out, that it doesn't, in that webinar invitation itself, does not identify either of the applicants by name. But certainly that was sent out on the 5th of July. The podcast, where we are identified by name, was published 2 days earlier, and the podcast itself was broadcast a week prior to that. And there is the other article on the 26th of March, which did identify us by name. And so the submission we make is that anyone who was vaguely aware of the series, the special investigative project, Mashatile Unmasked, would know that the reference there would be to us. And certainly given the manner in which these particular journalists who were hosting the podcast had mentioned the applicants in their who were hosting the webinar, had mentioned the applicants in their earlier podcast, there was every reason to believe at that point that they would be named in the webinar. As it turns out, they weren't, and the reference, it is made in the paper somewhere, I can't get the exact reference, but where at the beginning of the webinar, the hosts actually hold up a copy of the letter of demand, and essentially that stopped the mentioning of their names. There was no further discussion of the applicants in that webinar. But the point I'm trying to make is that not only was there a sudden flurry of activity, which started with the initiation of this Mashatile Unmasked special project, but the respondents went beyond just using the term Alex Mafia that had been used sporadically over 16 years from time to time, mentioning the applicants. Here they start using words like mob, gang, and finally notorious Alex Mafia gang. And it was this combination of the number of publications, the time frame within those publications took place, and the escalation of the language that was used, culminating in the term notorious Alex Mafia mob, that served as the spark, with the letter being sent off just a short while before the webinar was to discuss the notorious Alex Mafia gang.
Sorry, I just need to unpack this submission. The words mob, gang, notorious were used at the webinar.
Were used in the invitation.
In the invitation, I mean.
The webinar invitation, yes. Directly in response to the Alex Mafia.
And when was the letter of demand?
It followed, it was sent the day after the invitation was released, just prior to the webinar going live. And so by the time, there wasn't much time between the two. It was sent quite late, but it was sent prior to the webinar and confirmed in the webinar that they had received it. And so it was this flurry of activity, starting with the project that started around the 26th of June, and the escalation of language used, and the promises that were made, for example, in the podcast for subscribers to expect more to come about these issues and about these people. That was really the straw that broke the camel's back, and that was then when the letter of demand got sent off, focusing on the various articles and seeking the undertakings and the apology and the retraction.
So, if one compares what was said in the 11 months before this, in the 22nd of August letter, how does it compare? What is mentioned in that letter? In that publication?
Yes. Well, that publication refers back to Mr. Basson's original letter from 2007. I think it includes a hyperlink to that publication. And it's pretty, in large part, looking forward, looking at the upcoming elective conference, looks backwards to provide the history. And so it was cause for concern that after all these years, again, and it's back in the public domain, but it wasn't clear at that point what else they were going to be publishing, and that was in the run-up to the elective conference. There was that one other article, the Daily Maverick article, and then again there was silence. And when you compare that, so there was that, the language of mob, gang, notorious gang, that type of language wasn't included in the 22 August, I was going to say 2022 article.
So I'm trying to distill what you submit was the trigger for the urgency, because everything substantively had been said during, again, on 22 August 2022. Am I correct? Other than there's been now, your submission, if I understand it correctly, is that the language had escalated. There was now mob, gang, and notorious
Correct.
added into the mix.
So if there was any, let me start, try that differently. The respondents put up a particular interpretation of the meaning of Alex Mafia, and they say it's innocuous, it's just I think the word they use is nickname. I'm not sure if it's, certainly the applicants don't understand it as being a term of endearment, but that type of interpretation may have been some merit to it back then. Not conceding on that point, but saying some people may have understood it in that type of a context. But when you start throwing words such as mob, gang, notorious mafia gang together, there can be no doubt that the use no longer, if it ever had, has an innocuous nature.
So, to distill, up until 22 August, there was, it arguably had a innocuous meaning.
Yes, it may have.
And what changed was actually in the invitation to the webinar.
It was before the webinar. There were the use of mob and gang came in prior to that, but it really the height of the escalation was then. There is a subsequent publication which came after the letter of demand was sent, and that is the Netwerk 24 publication of the 7th of July. That's the opinion piece written by Mr. Spies, the 8th respondent. And we deal with that starting at page 01-31 of the founding affidavit, paragraph 69. And the title of that article, translated into English, Alona Junior has been doing much of the translation, as Afrikaans is her home language, but I don't think it's controversial.
It's not that crucial for me.
I understand. It's uncontroversial that the title of that article is From Alex Mafia to Mafia State. And it's an article that focuses on that horrific incident that took place, or that was videoed on the highway, where members of the Deputy President's VIP protection unit were videoed, at this stage, they allegedly beating up people on the side of the road. And that's the focus of Mr. Spies's article, but he then deals with the Alex Mafia, refers to the Deputy President as the Don of the Alex Mafia, and then the piece ends with South Africa is a mafia state and the Don is only a heartbeat away from the presidency. And so that letter came, that publication was after the letter of demand, but before this urgent application was initiated. And so it was the flurry of articles by one publication that had made it clear that this is a special project that they are focusing on. This is a project of an extended duration. On their own version, this is a project that is going to last at least until the next elective conference. They make it very clear, the respondents, that it's their right and obligation to report on the Deputy President in the run-up to the next ANC elective conference, where they expect him to be a candidate for election to the presidency of the ANC. And so you get, it's the flurry of articles, it's one publication having a dedicated focus, making it clear that this flurry is going to, that it's going to continue and it's going to be sustained. It's the escalation of language, and it's all of that collectively where the applicants say, this is too much, we need to put a stop to this. And it's that results in the letter of demand being sent out. There's then the publication by Netwerk 24, where no longer are we just members of a mafia, but South Africa, but we're going from a mafia, from the Alex Mafia to a mafia state. Certainly that type of language is not innocuous. It carries very negative connotations. And that's then when the application gives rise to the application. And I think it's not in contention that from that moment on, we moved very quickly to get the matter before this court. And so the primary objection is that we've been waiting since 2007, or alternatively, we've been waiting since 22 August 2022, and we should have acted sooner. And our position is we weren't comfortable with what was happening before. We didn't like it, but we could live with an article here, an article there. It's in the media for a day, it fizzles out. But when you have a sustained focus on you in articles that are not about you, so if one looks at all of the articles that we have complained about, the articles are focused on Mr. Mashatile in the here and now and looking forward. Where we are mentioned is always in the past and in the distant past. They're not about us. They're about his current contacts, about people like Mr. Sodi, about his VIP protection unit, about a bunch of other things. When we get brought in, it's back to the allegations relating to what allegedly happened in the early 2000s. And all the references to Alex Mafia are to those, but they get muddied. And it's in that context that the applicants say, we need to take action now, because now the game has changed. We are going to be in the media now. They are telling us they are going to be repeating this over and over and over again. And that is what sparks the need for this application we submit.
So your complaint is that historical facts are repeated, even though they are repeated as historical facts. So they were mentioned in 2007, and then on a number of times as set out in your chronology. Then they were mentioned again last year, and every time the press refers to it, it is referred to correctly, historically, but it's the repetition and the potential for confusion in the public mind, that is problematic for the applicants.
Well, lady, not entirely, no. We don't accept that these are historical facts. What is a historical fact is that those allegations were made as far back as 2007 in Mr. Basson's article and in the various articles since then. And the allegations have been repeated. The replying affidavit deals with some of those allegations. It doesn't deal with all of them, but it does deal with some of them and goes to some extent to explain why the allegations either have no merit or why they are misleading. So we don't accept that what is being reported on are historical facts. What has been reported on from time to time are allegations, and in particular the reference to the so-called Alex Mafia and what is meant by that. We do make the submission that throughout the use of the word Alex Mafia, the use of the term Alex Mafia has been defamatory. I don't want to be misunderstood as having made a concession that we say it had an innocuous meaning, but we're saying if it did have an innocuous meaning at that point, one can't say that going forward with gang and notorious gang. But our point is that the use of that reference has always been defamatory, and that what has happened over time, and including in that article of August 2022, is a repetition of what gets presented as fact, without any interrogation of all these years later as to whether or not what was originally published was in fact fact. We say for various reasons it's not, and that article is not why we're here before court. We're here before court because of the special investigation which keeps on reporting on us, presenting allegations as fact in articles that are not about us, in a sustained focus that they say will continue for the next few years, and where we see a progression in the use of the language and the type of allegations.
You say you're here because of the special investigation issue, but that's not the way the notice of motion was initially formulated, and there's been a shift which happened in the replying affidavit. But you say that that's your fifth rubric that you will address the court on the amendment.
Yes.
But this does all feed into the urgency feature, the urgency argument, because the case which was presented in the founding papers did focus on that article
It included a focus on the article, but was not, and part of the relief in paragraph 2.2 of the notice of motion referred to that, but the relief in paragraph 2.1 in large part mirrored the initial demand in paragraph 9 of the letter of the 6th of July. In the papers, a slight expansion, and then for the reason we'll come to, a narrowing of that. Back was the original complaint as set out in the letters of demand of 6th of July and 10 July. But I think the main point I wish to make is that we haven't been sitting waiting since August of last year to bring a matter. It was what happened towards the end of June and in early July that sparked the approach for an undertaking, for articles to be removed, for apologies, and for certain undertakings. And when those were not forthcoming, that was then when the application was launched. I will leave it at that. Lady, if I can then move on to the meaning of Alex Mafia. And for this, I want to take you to my heads of argument, starting at paragraph 40. That's where the topic begins, but I wish to begin at paragraph 41 of the heads of argument. And I don't intend to take you through all of it, but there are just a few things I wish to highlight. We set out the test for determining how a court goes about understanding whether words used in a particular context are defamatory, and we set out the test from LaRue versus Day, and this is paragraphs 5, 6, and 7 of that judgment, here still in paragraph 40. And I'm just reading the underlined portions. The first is to determine the meaning of the publication as a matter of interpretation, and the second, whether that meaning is defamatory. And in determining what the meaning is, the question to answer is, how would a reasonable person of ordinary intelligence have understood it? We make the point in paragraph 41 that it's common cause that both News24 and Netwerk 24 have published articles that interchangeably refer to the applicants as core members of the Alex Mafia, a sinister network, a mob, and a notorious gang. These have been republished and commented upon by News24 journalists, including some of the respondents in various tweets. The replying affidavit goes to some length to show what the respondents did following the filing of these urgent papers. My lady will know from the replying affidavit that there was another article that was published post the initiation of proceedings. We deal with this this is dealt with in the replying affidavit, and then there were a series of tweets where some of the respondents republished that particular article, which obviously included the statements that we sought in undertaking that they wouldn't publish, and then there were comments made in the retweets, or the quote tweets, I think is the term we use, and then in responding to various members of the public who replied to the quotes. I'll leave it there. The respondent's approach in seeking to attribute a meaning to the phrase Alex Mafia is to focus on a particular dictionary definition. And this is in the answering affidavit at paragraph 65, page 01-187.
Sorry, can you just give me that reference again? I know that
it's the answering affidavit at paragraph 65.
Yes.
And it's at page 01-187. Where they say as follows: according to the Collins Dictionary, mafia does not necessarily refer to an Italian criminal syndicate. It can also mean any exclusive or dominating group. This is obviously the sense in which Alex Mafia is employed. We have a number of responses to that. The first is purely on the dictionary definition itself. And the replying affidavit sets out that Collins Dictionary itself
has a number of
different definitions, most of them not having the kind of innocuous type of meaning that the one they choose has. So why would one choose one out of a series of meanings? Why would that be the obvious meaning to go for? Why would one go to a singular one dictionary and not look at how do other dictionaries deal with it?
Have the applicants referred to themselves as the Alex Mafia at any point?
No. The allegation is made in answer that we do. I think it's in paragraph 63 of the answering affidavit, and we do deal with that. 47. And we do that is dealt with in reply. The allegation is made that we don't deal with it expressly, and therefore we must be taken to have admitted it. I think it's in the context where the answering affidavit refers to Mr. Dutoy's confidential source saying that the applicants refer to each other as this. And in reply, we say, well, this is merely hearsay, and you, absent an application to admit hearsay evidence, the court can't take notice of that. They say, well, we don't expressly deny it. But our position is, by raising the point, it's effectively a denial. One must understand also that we had initially set certain timelines. We filed the papers in the very early hours of the Tuesday morning. So the applicants would have had the papers first thing on Tuesday. We gave them until the following close of business the following Monday to answer. we got the answering affidavit, I think it was about after 9 p.m. on the Tuesday, a day later. And so the reply, papers had to be in by noon on the Thursday, so essentially there was a day for us to do a reply. And it's in the context of that that one must understand how it's very difficult to respond very in that time. And so where the response is that the evidence on which you rely is hearsay evidence for that allegation, and we submit that evidence is not properly before this court. This court should read into that we dispute that evidence.
And has Mr. Mashatile referred to the applicants in those terms, to himself and the applicants?
He has. As far as I understand, he hasn't referred to the applicants, certainly not in the papers. And depending on where one looks, sometimes he understands the term, well, in an article to which the respondents refer, he understands the term as being, I think he said it's political, and he doesn't take much offense. With respect, I think that Mr. Mashatile has much greater things to concern himself with. But be that as it may, he does, at one point he says, well, he doesn't have an issue with it. But elsewhere, if I remember correctly, it's in the Daily Maverick article of 2012, where there's my journal will find the reference, where he says he was not comfortable with the use of it then. But I don't believe there's anything in the papers where...
I think he's quoted in the papers. He's quoted as what his meaning of what he contains.
But I don't think he mentions the applicants in that.
No, but you've now just read to me how from day and how I'm supposed to be interpreting, or how I'm supposed to find the natural and ordinary meaning
Correct.
of the publication.
Correct.
And I must ask myself, how would a reasonable person of ordinary intelligence have understood it? Now, the person at the scene of accusation understands it in a particular way. I've got that. Now, my question to you is, how much weight, if any, am I to attribute to what he says, how he understands it? Mr. Mashatile.
In a very recent article.
Yes.
I'm not sure if this court should attach
Any weight
much
to
weight
it.
or any weight at all. And what the replying affidavit does do is it puts up a tweet by a former premier of this province, Mr. Shaloa, who was premier at the time when Mr. Mashatile was an MEC. And it's discussing this particular application before court, and Mr. Shaloa says he understands the reference to Alex Mafia in the same way that the applicants. You can find that annexure or that reference to. But certainly, if your leadership is going to pay any attention to what the Deputy President, who, as I said, has a lot on his plate, and that's arguably the least of his worries, is a reference to the Alex Mafia, so-called Alex Mafia, one should equally then look at the Premier at the time, how he understood that, or how he understands that now. But I think
During the
bigger
adjournment, can we just have those two references?
Sure.
Perhaps we can find those two.
So the reference, the tweet itself, Mr. Shaloa's tweet is at page 01-441. Maybe if I can just place it in context. There's and this is Annexure RA 15 to the replying affidavit. There's an article published by News24. It's published on Twitter. Mashatile's friends launch urgent court bid to stop News24. Stops it. I think it was calling them members of the Mafia. So that was their own headline, how they understood the application. And it includes a photograph of the two applicants, with Mr. Mashatile, with Mr. Kakana, and with another former premier of the province. And Mr. Tebogo Kaas tweets, "The Alex Mafia discovery process will make for interesting observations. Will associates face scrutiny and possible legal exposure?" And then that's on July the 23rd. And then Mbazima Shalowa, the former premier of the province, says, "I don't think they're contesting having done work or worked for the GPG, Gauteng provincial government. It is that they're a marauding gang that milked the state through illegal means, and the connotation of what mafia in that context means. Can't wait too. Remember, burden is not on them, but on publication." So, a very clear understanding by Mr. Shalowa that he doesn't see those references as being benign. But the point that the submission we would make is that actually neither of them are really important in this. One must understand the type of publication that News24 primarily is, and it's an online it's a digital publication where the bulk of it, or a large part of it, and certainly many of these articles that we're talking about, are ordinarily behind a paywall, and you have to be a subscriber to read the articles. And not only do you have to be a subscriber to read the articles, but you have to be a subscriber to comment on the articles. And we deal with this is dealt with in reply, where we give a summary of, I think it was 97 different comments that had been made by the time the reply was finalized. And if you look at the comments that subscribers make, it's very clear in their minds that the use of the word carries all the negative connotations that we say it does. That's dealt with quite extensively in the replying affidavit. There's a summary of some of the types of comments, and it's all linked to criminal activity and corruption and nepotism and things like that. And so one is looking at, well, what is the evidence before the court as to how people have interpreted the phrase. We submit that one must look at how subscribers themselves, who have an interest in following News24, are prepared to pay a monthly subscription, and are likely not only to have read one or two articles, but to be aware of the series of articles, and to how they themselves understand the term as used in context. And that's quite different from looking at a dictionary definition. So I've already mentioned the concerns we have about cherry-picking one dictionary definition out of a bunch of definitions, the one that's the least offensive. But our second concern in that regard is the point we make in paragraph 43 of our heads of argument, and that is the role that dictionary definitions may play in this process. And we rely here on a recent,
All right.
relatively recent
Before
UK
you now
Supreme-
move on to that, I think I'm going to take the tea adjournment at this point. Before I do so, I see some people in court, and I just want to see whether I can assist Mr. Peter.
Court please, Valerie, I'm just on watching, waiting for trouble that may come. So.
Oh dear, that doesn't bode well. In the matter which stood down,
That's matter 26.
is anybody here in matter number 26?
I checked with 9E. There's no statement by the name of Abdi. The notice of motion says Abdi Abdullahi and Abdi Ahmed. There's no one by the name here.
All right, Mr. Governor, will you leave your particulars with my registrar? And if somebody arrives during the day, we might contact you. I'm just concerned, as I mentioned initially, that it might be a person unrepresented. But for the moment, I'm going to strike.
My lady, if there's any way we can attend to the issue of cost for our appearance, because we have no understanding of why we should be at court, save for being served yesterday to appear in a matter that there's no appearance and we need to make submissions, and there's been necessary costs incurred by our client
Yes.
to attend to this matter. That's before your ladyship.
Ordinarily, I would have granted you costs, but because this person is unrepresented, I'm going to reserve the issue of costs, and there's nothing urgent about costs, and you can deal with it in the fullness of time if necessary.
Indeed, sir, your ladyship. So I will wait for your ladyship. If there's anything from your ladyship, we will receive a notice to appear and the necessary order that your ladyship will direct in due course.
Yes. So in matter number 26, I'll make the following order. The matter is struck off the roll for want of appearance on behalf of the applicant. I record that Mr. Govender is here on behalf of, well, not the respondents, but
The respondent that
Yes.
you are appearing, that's Rimco Proprietary Limited, RYMCO.
Rimco.
Yes, Rimco Proprietary Limited.
Yes.
That's who we are appearing here.
And the costs in respect of Mr. Govender's appearance are reserved.
As business.
Court will adjourn.
necessarily have an issue with it. Yes. Yes. So,
So it's not what somebody says about him, it's
Yes.
where he's quoted. Oh, here we go. It's in paragraph 3 of the respondent's heads of argument.
yes. That's as far as I can take that. Oh, sorry, my lady, my junior points out that the article, the interview that Mr. Mashatile gave, where he made that comment, predated this particular article. And if you go to paragraph 62 of the answering affidavit, that's at page 01-186. Mr. Basson says, "We did not coin the term Alex Mafia. It originated in political circles and in fact within the ANC itself. Mr. Mashatile himself explained this in an interview with the Financial Mail, as recorded in an article dated 4 August 2022. So,
Paragraph 62 of the
answering papers. So the quote came in that Financial Mail article, which is then recorded in an article 4th of August, and then a couple of months later, he's reported, not quoted, but reported as not being comfortable with it. But our submission remains that how he understood it is not necessarily, or is not at all indicative of what the reasonable reader, who's not involved in the rough and tumble of politics and who ordinarily, if that's all that is thrown at them, might consider themselves lucky. The ordinary reader used to have a very different approach, and for that we then refer to the comments by subscribers. Just before the adjournment, I was moving on, dealing with the issue of the role that dictionary definitions may play. And the reference here is to the UK Supreme Court judgment in Stocker versus Stocker. It's dealt with in paragraph 43 of the heads of argument, where the UK Supreme Court drew attention to the danger of the use of dictionary definitions to provide a guide to the meaning of an alleged defamatory statement. The court said as follows. This is at paragraph 25 of the judgment. The court said, "That meaning is to be determined according to how it would be understood by the ordinary reasonable reader. It is not fixed by technical, linguistically precise dictionary definitions divorced from the context in which the statement was made." Now, lady, that was a defamation case where Mrs. Stocker, the respondent or the defendant, had posted on Facebook and had alleged that in a particular vicious altercation with her or ex-husband, he had tried to strangle her, and the trial court had relied exclusively on a dictionary definition, and it said that they had confined the possible meaning of the statement to two stark alternatives. And this is how the Supreme Court described the trial court's approach. Either Mr. Stocker had tried to kill his wife, or he had constricted her neck or throat painfully. In the judge's estimation, the fact that Mrs. Stocker had said that her husband tried to strangle her precluded the possibility of her statement being taken to mean that he had constricted her neck painfully. So, relying on a dictionary definition, the trial judge said that the meaning to be attributed to the phrase "he tried to strangle me" posted on Facebook essentially meant that he tried to kill me. And the evidence was clear that that's not what happened. He wasn't and it couldn't have been understood as him trying to kill her. And the Court of Appeal, if I remember correctly, said yes, but the trial court didn't only used that dictionary definition to assist. The Supreme Court overturned that and said no, exclusive reliance was placed on that. The trial judge restricted the two meanings, and then when the one couldn't apply, picked the other dictionary definition. And they said that's not the approach, because you've got this sterile technical definition provided out of context. You've got to look at how the words are used in context to understand it. And so, and we say that is consistent with the approach in our law, as set out in LaRue versus Day, where you look at how the reasonable reader would understand it in the context in which the words are used. A point which I made earlier, and which I wish to just give the particular reference, is that one doesn't look at an article on its own. One must look at an article, if it is part of a series, as part of that series. And so this was in response to the issue I raised earlier about the webinar invitation not expressly mentioning the applicants. And the submission I made was that one must look then at the series, and in particular the podcast, the same hosts who had a few days earlier expressly identified the applicants. And the passage, the case on which we rely here is the case of Citizen versus McBride, where attention was drawn to the need for reading any particular publication as part of a publisher's coverage as a whole. And this is starting at paragraph 94 of the Constitutional Court judgment, where I think it's Justice Cameron says as follows: "It seems to me to be wrong to assume that newspaper readers read articles in isolation. This is particularly so when they read editorial comment or columnists commenting on current affairs. It is likely that in assessing comment, readers will bring to mind recent news coverage of the events in issue. This conclusion accords with decisions of the European Court of Human Rights to the effect that a publication alleged to be defamatory must be assessed in relation to the coverage as a whole. Considering the Citizen's coverage as a whole also accords with the decision of the Supreme Court of the United Kingdom in Spiller." We then go on in our heads of argument to deal with who is the reasonable reader, and in paragraph 49 of the heads, I'm not going to repeat those, we set out what I mentioned earlier, News24 being primarily offering subscription-based services. And so understanding that the reader of the articles would be a subscriber, and then it's in that context that we then looked at the subscriber comments. And we say at paragraph 50 of the heads, although not determinative, the subscriber comments identified in the replying affidavit give a strong indication that the reasonable reader of News24 articles is likely to interpret the reference to Alex Mafia in the manner contended by the applicants. The benign meaning advanced by the respondents appears to be wholly absent from their thinking. And then we refer to paragraph 17 and 18 of the reply, where that point is made. In paragraph 51, we go a bit further, and we make the submission that News24's use of the term Alex Mafia must be understood in the context of its reporting as a whole. And in particular, we make the submission that the reasonable subscriber would be well aware that the term Alex Mafia also exists alongside other similar terms published by News24, such as the taxi mafia, the construction mafia, the energy mafia, the tender mafia, and the mafia state. And then we set out in paragraphs 51.1 to 51.5 the various headlines of the articles that are attached to the founding affidavit. My lady, this came about because in some of the early correspondence between the parties. After the letter of demand was sent, the respondents said, well, yes, the term Alex Mafia must be understood alongside other terms that are used in the media. And they spoke about the Premier League, I don't wish to focus on that, and the Stellenbosch Mafia, and seem to suggest that when used in relation to the term Stellenbosch Mafia didn't connote any negative meaning. And it was in that context that when the founding papers were drafted, the applicants say, well, yes, it is used also in the context of you report on the Stellenbosch Mafia, and it may not necessarily have the same meaning, but you also report on all these other alleged mafias, or these mafias. And these are the types of articles these are all News24 articles. For example, Taxi Mafia blamed for deadly attacks on long-distance buses. SA Construction Mafia, 183 projects worth 63 billion have been hit by extortion since 2019. Fixing Eskom requires cleansing the sector of the energy mafia. That's an opinion piece, if I remember correctly. Authored by a columnist or contributor, not by a journalist. 51.4, Tembisa hospital staff who helped 1 billion rand tender mafia still at work. And then finally, edging closer to a mafia state. And so we say you can't just choose the example that you think suits you best. The Stellenbosch Mafia example may or may not have a negative connotation, but when you talk about all these mafias, clearly you're talking about them in a negative context, and the reasonable reader will be aware that this is how you report on people doing bad things. This is not an innocuous, friendly term. This is not a nickname. It's not a term of endearment in any way, manner, or form. We make the submission then at paragraph 53 that with examples such as these, the reasonable reader without a subscription, who ordinarily only sees headlines and tweets, is also unlikely to understand the reference to Alex Mafia in the manner contended by the respondents. This is particularly so when reading headlines such as the secret luxury life and state capture links of a president in waiting, Ring Bling's live pentagons and mafia mobs unmasking Mashatile's millions, and Van Alex Mafia tot Mafia start, from the Alex Mafia to the Mafia state. And then finally at paragraph 54, we say, instead, we submit that the reasonable reader is likely to understand that the applicants, as alleged members of the so-called Alex Mafia, are said to be a group of Mr. Mashatile's closest friends who have scratched his back while he has scratched theirs. They owe their success to him and could not have achieved that success but for their corrupt and nepotistic ways. The reasonable reader is likely to believe that the word mafia is a perfect descriptor. The distinction we drew in talking about the reasonable reader was between the reasonable reader who is a subscriber and would then have access to all the articles in full and would be able to at least get some of the context from the articles, as well as the reader who simply sees the headline or sees the tweet. And then if you click on the link...
When you say they've got access to all the articles, what is all
the articles that we've identified containing defamatory statements, that the News24 articles.
Does they have access to the 2007 article? Or are you saying that it's only from the 26th of June 2023? So which articles must they have, you say, must they have regard in order to form this view?
Well, we say they would have had access to all of these articles. Certainly the August of 2022 also then had a hyperlink to the original article. But the more recent articles, if they're currently subscribers, the likelihood is they were subscribers a couple of weeks ago, and these are the people who are leaving these comments. And so they would be able to read the text. The distinction we're trying to make is between those who read the articles that we've complained about in full, and those who merely see tweets and headlines. So whatever the journalists add to the published tweet, and then the headline of the article itself, because that you click on the link and you hit a firewall. And so in determining who is the reasonable reader, this court, we submit, would need to take into account both of these categories of readers and how the allegations would be understood. My lady, I'm not going to deal with the issue of whether the meaning is defamatory. We submit that it self-evidently is, and we explain why at paragraphs 55 and 56, or 55 to 58 of our heads of argument. I then move on to the substantive merits, and I hope I won't take very long on this. We have already dealt in large part with the issue of prima facie right. We make the point in paragraph 63 of the heads that a prima facie right may be established by demonstrating prospects of success. In this case was in the review, in our case in the action to follow. And they're really, in determining whether there's a prima facie right, we submit this court will have to consider two things. Firstly, whether or not we have shown prima facie that the words complained of carry the meaning we advance, and that they're defamatory, and then would be to consider what is the defense put up by the respondents, or the defense that they seek to rely on at trial. And with that in mind, we rely on the judgment of His Lordship Justice Wallace in the Herbal Zone matter. This is at paragraph 65 of our heads, where he sets out what a respondent in an application such as this has to establish, as opposed to what a defendant in a defamation action would have to establish. And we accept, as we must, that the full onus that is on a defendant in action proceedings is not the same, does not apply in the context of proceedings such as these. And as Justice Wallace said, what is required is that a sustainable foundation be laid by way of evidence that a defense such as truth and public interest or fair comment is available to be pursued by the respondent. It is not sufficient simply to state that at a trial the respondent will prove that the statements were true and made in the public interest, or some other defense to a claim for defamation without providing a factual basis, therefore. In the affidavit, the respondents rely on two defenses, one each in respect of the original prayer 2.1, one in respect of 2.1 and one in respect of 2.2. Sorry, I think our heads of argument get it wrong. That the defense of the defense of fair comment is in relation to what was prayer 2.1, and the defense of truth and public interest is in relation to 2.2. And as you'll see from their heads of argument, they focus on the defense of fair comment, because we're only dealing with, should the amendment be granted, we're dealing with the prayer that relates to the use of the term Alex Mafia and the naming of the applicants as part of the Mafia. What is important, and this is also important for purposes of the amendment, to which I'll come in a short while, is that in both defenses, in answer, they rely on the same set of alleged facts. And in both cases, they have sought to rely on the same public interest argument, whether for truth in the public interest or for fair comment. So to then get to the defense and what a respondent must lay by way of evidence in proceedings such as these. And we say, and this is at paragraph 70 of our heads of argument, we say that there are a number of problems with the defense that they set out in relation, the defense of fair comment or protected comment. And that's set out in paragraph 70. And there are two things that I really want to focus on here. The first is that there's a significant shift that takes place between the answer and the heads. So in the answer and in the heads, they persist in what is the proper interpretation of the phrase Alex Mafia and how those words are to be understood and interpreted. But for purposes of the protected comment defense in answer, they retain their benign interpretation and make the point that if that benign interpretation is understood to be defamatory, then it's protected comment. And the argument made in answer is that the alleged facts on which we rely, those are the facts stemming from the 2007 article, which they've relied on for both defenses in answer. Those facts justify the sincerely held view, opinion, that the applicants form part of the Alex Mafia. But that's based on a meaning, the Collins Dictionary meaning that they have chosen. When they get to their heads of argument, they adopt a different meaning for purposes of that defense. And they then adopt a meaning that has significant negative connotations. And so the point we make here is, firstly, we say there's been an impermissible change in the case. The defense, as set out in evidence, is not what you're arguing in your heads. But more importantly, there are two key things that the defense of protected comment requires. The first is that the facts upon which you rely must be facts that you rely on for an honestly held opinion. Now, if your honestly held opinion, as Mr. Basson sets out in answer, is that this is what those words mean, and we rely on these facts to support calling them members of the Alex Mafia because this is what we understand Alex Mafia to mean, then you can't come in heads of argument and say, well, actually, we've changed our view on what our honestly held opinion is, because it's not honestly held. The honestly held opinion, as set out under oath in answer, is that it has this meaning. And so they must be tied to that as the meaning, because it cannot be honestly held if that is not the meaning that they relied on for this particular defense. The second point, and we say equally problematic, and we deal with this at paragraph 70.4 of our heads, is that they don't explain and why it's in the public interest for them, when reporting on the Deputy President, to not only mention the Alex Mafia, but to identify us as members of that mafia. We say at best, they may have set out a basis for providing historical context, but that does not even go close to seeking to justify why the applicants should be identified when the stories being investigated now are not about them. And so, for purposes of argument, let's say that there is an article that they are writing now about what the applicants are alleged to have done last week. Then it may, I'm not conceding it is, but there may be a case as to say, well, we're focusing attention on them now. They're in the news now. Let's look at what happened what was reported on 16 years ago, what happened earlier than that. But that may make sense. But what they haven't explained to us is why now, when you're reporting on the Deputy President, when you're reporting on the Deputy President's alleged links to Edwin Sodi, when you're reporting on or publishing pieces, the thuggery of the VIP Protection Unit, why in those pieces do you have to dredge up stories about, not only about mentioning the Alex Mafia, but name us as mentions of that mafia when we are not relevant to what is happening today. And it's in that context that we mention in the early paragraphs of our heads of argument the McBride judgment, where the Constitutional Court asked and answered the question as to whether you can keep on raising defamatory allegations indefinitely. Does this mean that, and this is at paragraph 79 of the Constitutional Court's judgment in the Citizen versus McBride, where the court said, does this mean that despite amnesty, McBride's conviction for murder can be flung in his face? Can he be called a murderer forever and a day? They say then the common law defamation conformity inhibits indefinite reconjuring of past issues. The defamatory articles in that case arose in the context where years after Mr. McBride's conviction for his role in the Magoo's bombing in Durban was raised by the Citizen as one of the reasons why they were of the view that he was not fit to be appointed to head the Metro Police in Ekurhuleni. And so the focus, at the time the articles were published, the focus was on Mr. McBride, and the successful argument that was made was that it was in the public interest for them, the publishers, to raise Mr. McBride's past, and that then follows then with the paragraphs that go on about how comment can be particularly nasty and pernicious, provided it's sincerely held comment, an opinion, and on those facts. And they deal with the issue of whether at that point it's in the public interest to raise his past. We say the facts here are very, very different. The stories that are being written now are not about us. They're about other people, and we get thrown in, we become collateral damage, and no public interest argument has been properly made out to justify why we must be named. That's all we're asking for now. We're not saying don't speak about the Alex Mafia ever, or the alleged Alex Mafia. But if and when you do it, and it's appropriate to do so, there's no need for our names to be mentioned. That then takes me to the second leg of the test for interim interdictory relief, and that's the fear of irreparable harm, and I deal with it starting at paragraph 74 of the heads of argument. And there are really 2 points that I wish to make here, and I hope to do so briefly. The first is that our courts have recognized that the fact that defamatory allegations have been made about you once before doesn't mean that when they are repeated, you don't suffer harm. And that the point that the applicants make, and this is at paragraphs 78 to 80 of the founding affidavit, is that every time this is brought back into the public domain, it hurts us and it damages our reputations. And they say not only have you done it and done it repeatedly, but you've made it absolutely clear that you're going to continue doing it. And we see by the respondents' conduct once the papers were filed how I think we've relied on 2 articles published post-filing of papers. One immediately and one, in fact, that was published following the delivery of the answer that we picked up just before finalizing the replying affidavit, where the allegations get repeated and repeated. And so one must look at the conduct of the respondents and must believe them when they say in the podcast that they're going to continue doing it. They want to be able to continue. That's why they're here. If it didn't matter to them, they may not be here, but they want to be able to continue to refer, to use the term Alex Mafia and to be able to refer to us as members of the Alex Mafia, regardless of whether the stories are about us or not.
And other publishing houses?
Well, at this stage, there's no indication that anyone else, no one else has shown us that they have any similar intention. In answer, the most recent article that the respondents put up was that Daily Maverick article of 7 December 2022. But we haven't seen any sustained focus. The respondents do ask, why are we not seeking interdictory relief against Mr. Spiss, the 8th respondent? That's for a number of reasons. One is he's an attorney in private practice. He's not a journalist. He's not a reporter. It was a once-off that he wrote. There's nothing at this stage to understand that he's going to be writing any series. That's why we haven't sought any interdict against him. That's why we focused on Media24, and in particular, first News24 and then Netwerk für den Twinacht. We do make the point that it is likely that if the interdict that we seek is granted, then other publications would be careful. Even though there isn't an interdict that applies to them, they would be careful not to republish the defamatory allegations. It's not made as a threat. It's made simply to observe that the fact that there is no order against any particular publication doesn't mean that the granting an order against one is not going to affect the conduct of others. We say it's a big leap to go from that to making the submission that we bring in this application to strike the fear of God into everyone else. That we say there's no evidence for that. But certainly an order against a publishing house who has shown that they're intending to publish this whole series would give others cause for concern.
So then, what do you say of the slap accusation or submission?
So there simply isn't evidence to support that finding. We understand that those types of actions take place, and we're aware that of other matters that have been in this court, including, for example, the Mazzetti case, the matter that was before the Deputy Judge President, where the order had originally granted on an ex parte basis. so that this is fundamentally different from that. Here, and it comes back to the point about this not being the type of prior restraint order that those cases talk about. Those cases are about preventing you from publishing something in the first place. That's what they are primarily about. That there's a expose that is about to be published which breaks news, and you rush to court to stop that from coming out. That is where we understand those prior restraint cases to deal with that. Whereas here, what we're talking about is something quite different. It's stuff that's already out there. It's stuff that the public knows about, but that gets repeated and repeated, often in a way that readers can no longer forget, because if you publish one piece 1 year and another piece 3 years later, it's very different from if you're publishing every few days. And then with the escalation of the language used, that is where the harm comes out. And we're saying this is not something that it's not something that we think there'll be harm in the future. We've seen it already. It's already happened. They've published this, and they are going to do it over and over again. They tell us they'll do that. So we say it's not that type of lawsuit. There's no evidence on the record to come to that conclusion. If I can then move on to balance of convenience, and I wish to deal with that very briefly. Essentially, on the one hand, you have the harm that we fear, and on the other hand, we have what we submit is nothing more than at most minor inconvenience to the respondents. All we're saying is don't mention our names. When you, in your reporting on Mr. Mashatile, don't mention us by name. Stop doing that. And we say that really is at most a minor inconvenience, and it really, there's no public interest in our names being splashed across the media over and over and over again when you're not reporting about us. Finally, on the test for an interdict is the adequate alternative remedy, and we submit we can't wait until the conclusion of action proceedings, because even if those do proceed as fast as actions may proceed, particularly in this division with its busy role, it's going to be a while. We can debate how many years. Seemingly, what I read into the answer is that if the respondents were to lose in the action, there would certainly be appeal proceedings that would follow. But be that as it may, the point is that if they continue in the way that they say they will continue, then for as long as the action remains in play, unfinalized, the harm will continue. So that is why we brought the interim interdictory proceedings. The other point that the respondents raise is we ought to have lodged a complaint with the press ombud, which is quite an interesting point to raise, because if it's correct, we submit it isn't, but if it's correct, then it means you can never get an interim interdict against the media, because you always have to go by way of the press ombud. And we explain why the relief that the press ombud is able to give is not appropriate. It's not the kind of relief that we need to protect us from the harm that we suffer and will continue to suffer. Interesting,
well,
my lady.
Is that the point they make, or do they make it slightly differently and say that, well, you never say why you didn't explore that route, just as an addition or alternative, or you don't deal with it at all?
In our finding papers, we
Yes.
don't. No, we only deal with it in reply. where I think we explain why we don't believe it's an alternative. Now, lady, what is worrying to us is the reliance that the respondents place on one of your judgments, where they suggest that your judgment comes to the conclusion that one is obliged to exhaust the press ombuds complaint mechanism. And I understand that my reading of your judgment is that it was in the particular context of that case where particular remedies were sought. I'm sorry, my lady?
They had started there.
They came to urgent court. They were seeking a type of relief that is not available in urgent court that was available before the press ombud. And so a very different kettle of fish. It was before the court in that matter. And so we say it isn't authority for the proposition that they put forward. But it must be remembered the press ombud remedy it's a voluntary mechanism that has been set up, and to elevate that as to the internal remedy under PAJA that one is obliged to exhaust, we believe there's no legal basis for any such elevation. That then brings me finally to dealing with the proposed amendment.
Just before you move on to that, and this really is an urgency question, but it links up to this feature. Substantial redress in due course in the context of this urgent application is not the action, and it is to be distinguished from that scenario, because the substantial redress in due course would be to bring an application in the ordinary course for an interdict pending the finalization of the action. So what is substantial redress? When will you be heard in this division if you had brought a normal application?
My lady, if I remember correctly, there was a directive that was issued within the last few days by the Deputy Judge President, where I'm subject to correction, where he says, I think once an application, an opposed motion is ready to be set down, I think the waiting period is 8 weeks from once it's ready. So if one then looks at the ordinary periods for answering affidavits, for then replying affidavits, then for heads of argument, both sets of heads of argument would have to be set down, have to be delivered before one can approach. We're looking at haven't done the arithmetic, but a number of months before you get to the point where you're then ready for the further 8 weeks. And so we're looking at minimum 6 months, possibly longer, before you can be heard. If it were to be, one could imagine that it's quite possible that a matter such as this, if it were to be on the ordinary opposed motion roll, would be set down as a special allocation. And even that then might even take longer. So at minimum, I would submit to you, you're looking at something like 6 months, 5 to 6 months before it would be heard. And given the harm that we say took place just in a week, and the articles that have been written since then, and the fact that Mr. Mashatile is in the news almost every other day, possibly every day, the likelihood of the repeated it's going to, there'll be damage, and it may not be the same extent of damage if one is waiting for the outcome of a trial, but certainly it's months of an onslaught. that we would be facing.
So I know that currently opposed motions are being enrolled the first week of October. So that's just around the corner, but that's of course assuming that all the papers are in order and it's finished. It's ready for hearing.
Yes.
But there is also, of course, also the rule which permits semi-urgency in this division, where you can approach the Deputy Judge President for a special allocation. So that's also available. That wasn't explored in this instance, was it?
No,
No.
it wasn't.
Right. Where's your draft particulars of claim? Does anybody know what you're going to be seeking in the fullness of time?
No, haven't drafted particulars of claim. We certainly didn't have time to do that. And we do say that it's an action to be instituted within 30 days. But we do set out in some detail in the founding affidavit what it is about the various articles that would be the subject of that action, what it is that we find defamatory. And that is then, I went through that a bit earlier. I'm not in the detail that's set out in the founding papers, but they know what are the statements that we're concerned about, which articles we're concerned about. That list of articles may well grow. Certainly, there have been articles. There have been 2 articles since the founding papers were drafted. It may grow within those 30 days. But there is no particulars of claim. They are aware of what the case would be about.
So I just need to understand what you would like, how the relief, so you have no quarrel with the media to report on the Alex Mafia, as long as the applicant's name is never mentioned in that context. So whenever there's reference in any of the publications to the Alex Mafia, they can never mention the names of the applicants. Is that your position?
Not as extreme as that. I think
but that's what you said just now.
The order has
You
been
said
drafted.
when you mention it, don't mention us.
Correct.
So that's what I understood
Correct.
you.
In articles that are not about us. I think that is, it's not in the notice of motion, but that's certainly the way the case has been argued on the papers, is that our biggest problem is not that you're talking about an Alex Mafia that someone isn't going to remember what was necessarily published in 2007. If you something a week ago where we were named, and then you publish the Alex Mafia without our name, then it's within the context of that series of publications. But we're saying ordinarily, when you report on it, it's not a problem. Articles are not about us. Obviously, a different calculation would need to be taken when it were an article to be about us, just as when there were articles about. And the question then is it in the public interest to mention his past? And I can give you an example. If there happened to be, I don't know, an article about one of the applicants that doesn't mention any kind of, let's say it's an article that's a positive article about them. I'll think off the top of my head, Mr. Sithole's role in Mr. Mashatile's charity. It's in the founding papers. The charity named after his late wife. If there was an article about the good work that he is doing, we say it wouldn't be appropriate to refer to him as a member of the Alex Mafia. But if there's an article which is alleging that he's doing X, Y, and Z that is deeply problematic. If it's relevant to the story, then there may be, depending on the nature of the article and whether or not there's any, it's in the public interest to report on historical matters from 20 years back, 15 to 20 years back. So I accept that as it's currently framed, the notice of motion goes a bit beyond that, or even as amended. But our primary concern is don't mention us in articles that are not about us. That's the refrain that has been used throughout. If your ladyship would be helped, we could put together an amended draft order that could take that into account. We can make that available to the court.
Look, you're going to deal with your current amendment.
Correct.
So
let me do that
don't
first.
amend further before
Correct.
anything has. So we're moving into that terrain now, as I
Correct.
understand your argument.
So, yeah, the last issue we raised, I see. So I've been going for some
You
time.
have. You've overshot your. You haven't really.
Still within budget.
Oh, goodness. Yes, but we did agree
I
it
know,
wasn't
I
a
know.
target.
No, I accept, my lady. And we deal with this from paragraph paragraph 12, where it quotes the passage from Sithole's reply where he annexed the proposed amendment. And we seek to remove 2.1, 2.2 and their entirety and replace them in their entirety, just to make it simpler. But actually, we're getting rid of a set of prayers and bringing a set of completely different prayers. Essentially, what we're doing are three things. The first thing is the prayer the old prayer 2.2 that deals with the interdict sought in relation to the allegations, made in the 2007 article. We effectively abandon that relief. We seek to abandon that relief. The second thing we do is we narrow the relief sought in prayer 2.1 insofar as it applies to Media24, but not the other respondents. And there we've listened to what the respondents have to say about if the interdict were to have been granted in the exact form in which it was sought, what obligations it would impose on Media24 in relation to all its other titles who are not here, in relation to subscriber comments that are placed online. And we've listened to them and we've said, we hear you, we're not seeking that. What we want is to limit, insofar as Media24 is concerned, who was cited as the publisher of News24 and Netwerk 24, limit to what they publish in those titles and what their journalists publish, not what others may put on as comments, and not any of the other news Media24 publications. We're not trying to block you or Drum or Huisgenoot from making these allegations. Didn't imagine it would be something that they would be publishing about. The final amendment is in relation to costs, and that really is not a substantive amendment. Initially, we sought costs against Media24 as the publisher, against any of the other respondents who opposed. All the other respondents opposed, but for Mr. Spies, so clearly no cost order is sought against him. And we have proposed an amendment that simply doesn't seek to journalists should their employees pay the costs will. And so it's really, in substance, nothing that they can object to. To the extent that there are objections, it's to the removal, the abandonment of PRED 2.2 and the narrowing of 2.1. My understanding is that the opposition is against the amendment as a whole. They haven't said, and they've raised a number of grounds of opposition, some procedural, that we didn't give the requisite 10 days notice, which...
Well, let's just deal with the
yes,
substance.
The substance, correct. There are two substantive issues. The one is whether the amendment has been put in bad faith, and the second is whether there's been prejudice to that can't be by an appropriate costs order. On the issue of prejudice, the issue of whether it's been brought in bad faith, what we've done is respondents have said it's probably an interaction that should have happened before, and we don't understand why they should object to us seeking a interdict. It's not a different interdict. It's simply saying we asked for A and B, we're not asking for A.
Brought to court to meet this big case, brought in with enormously truncated time periods and with everything. So now you are focusing, taking away the weaknesses in your case and focusing on the stronger parts of your case, in inverted commas, or where you think you will be successful in, but we have had to deal with absolutely everything. So firstly, you should have filed an affidavit explaining why you approached the court in the manner you did, not cast such a wide net to deal with things covering a span of 16 years, and now you're only covering that which happened within the last month. And so you didn't file an affidavit, you didn't explain your position, and from that we infer that you're mala fide. What do you say of that? Or you're not bona fide? Not you?
Yes, no, I accept that. Well, we have explained. We didn't do that in our founding papers. It's done, well, obviously not in our founding papers, because that was when we filed the papers, we were seeking the broad interdict. But that for me is more an argument that goes to prejudice than to mala fides. And we say the way in which the respondents have argued the fair comment defense is they've relied on all the evidence that they've put up in response to the other prayer. So the evidence that they've put up in response to whether or not the allegations in the 2007 article are fact. The bulk of their papers that they say we worked on to advance in support of our truth and public interest argument, they then rely on that very evidence for their protected comment argument. And so we say you can't come and say that had we brought the narrower case, A, you wouldn't have opposed at all. I think the papers make it clear, and certainly the continued opposition, that is the case. And secondly, that your papers wouldn't have fundamentally been different. It may have been, and certainly nothing that can't be addressed by way of a ordinary cost sort. So if this court were to find that had they only been required to defend a narrower case, it would have been they would have expended fewer resources. In that case, then that can be adequately catered by an appropriate costs award. But the mainstay, the thrust of their argument, of their defence of fair comment, relies on the very evidence that they put up in respect of Prayer 2.2. And so, in those circumstances, there is no prejudice. On compelling them to answer in a truncated period, they were given quite a fair amount of time in the context of urgent proceedings. They were warned the week before that this application was coming. Then we had identified the articles that were problematic. They knew what the case was about, and we filed on the early hours of the Tuesday morning. They answered in the evening, late than evening on Tuesday of the following week. So even though in practical terms they had 5 court days as well as the weekend, they actually had 6 court days and the weekend. So 8 days to prepare an answer, which we say is more than adequate. And ultimately, the key point that they have pursued throughout is that you have nothing to complain about because these allegations have been around forever, and there is nothing defamatory about the use of the term Alex Mafia. That is the mainstay of their case, and that is the case that they would have made out, I submit, had this case been initiated using a notice of motion along the lines of the proposed amendment. My lady, those are our submissions.
Thank you, Mr. Berger. Mr. Du Plessis?
Thank you. I just get to snaffle the lectern. Thank you. Thank you, my lady. I hope to be considerably shorter than our learned friend, and I will try and narrow the argument as best I can. We say, as my lady would have seen, that the application is indeed an abusive one. It's an abusive one because it's aimed at gagging the term. We now understand that's the real issue, supposedly, for our learned friends, Alex Mafia, and the notice of motion, as sought to be amended, which would effectively prevent any description of the applicants as being part of the Alex Mafia. And so that is the target. But, my lady, there is, and I'm going to go straight to the heart of what now seems to be our learned friend's case. The applicants are popularly known by that appellation, my lady. They're called that by politicians. They're called that by themselves. That's what they themselves have said is their association and how they recognize it. They are the Alex Mafia. And that's been so, my lady, for at least 16 years. My lady, you had a debate with our learned friends about this, but you didn't get a satisfactory answer. They call themselves that, and we've said it in our answering affidavit at paras 62 and 63. It's case lines 01, 187 to 188. My lady, it is said there expressly...
Sorry, what's the reference?
It's paras 62 and 63, 01, 187 to 188. My lady, that is said by us in the answering affidavit. And it's said by us expressly quoting, my lady, it's important to have a look at it, the financial Maile article where Mr. Mashatile is himself quoted. And if you go with me first to...
Mr. Du Plessis, I have a difficulty at present.
Okay.
I'm going to take a 5-minute adjournment
Yes.
just to deal with my difficulty here with my laptop.
My lady, that's absolutely fine.
Ms. Twaku.
You're looking for case lines 187 to 188. In fact, it starts at 186.
Court will adjourn.
All right?
Sorry about that
Not at all,
interruption, but it's all functioning again. And I am to find page
It's page
01.
186, paragraph 62.
Yes.
Lady, I was making the point that this appellation, which has caused so much consternation to the applicants, is an appellation which has been used widely and is an appellation by which the members of the Alex Mafia, and the applicants don't deny that they are members of the Alex Mafia as that term is described, those members themselves call themselves the Alex Mafia. So, my lady, you see that stated at paragraph 62. It's said by the respondents, we didn't coin the term, it originated in political circles, and in fact within the ANC itself. Mr. Mashatile, my lady, a member of the Alex Mafia, himself explained this in an interview with the Financial Mail, and you'll see we record it there, and the actual article is attached as AB22, which my lady will look at in her own time, no doubt. And it said there, he's nicknamed the Don of the Alex Mafia. Those quick to explain that the term simply refers to a group of 1980s comrades from the township who went on to serve in government. So we know two things. Three things. He's a member, he's the Don of it. It refers to a group of comrades from the township. Those include the applicants. And they went on to serve in government, and we know that that's true of the applicants as well. And he then, at the end of that passage, or paragraph rather, you'll see, he says it's political. There's nothing illegal about it, and he says that with a laugh. Now, my lady, further on, over the page, at 101-187, the respondents specifically put up, through a confidential source with direct and detailed knowledge of Mr. Mashatile's history and the inner workings of the group known as the Alex Mafia, something that was confirmed by that confidential source to Mr. Peter du Toit, who's the third respondent. And my lady knows that Mr. du Toit has put up a confirmatory affidavit to confirm what was told him by this confidential source. And this is what the source said, my lady. Everyone calls them the Alex Mafia. They call themselves that, and people in Alex call them that, my lady. My lady, in reply, our learned friend's best effort at getting away from this damning self-appellation, self-description, which Mr. Mashatile says is not illegal, says it's just political. In reply, my lady, our learned friend tries to get away from this by saying, well, it's not directly disputed, and that's probably because Mr. Mashatile is busy and thinking about other things. My lady, Mr. Mashatile is not in this case. Our learned friends are, and the applicants are in this case. It was a direct challenge. This is what is said. This is what is claimed to be the appellation and self-description. And look at what you get at page 01-388 in reply. It's paragraph 70 and 71 of the replying affidavit. My lady, it is evasive pleading with respect. It said, as explained in my finding affidavit above, Alex Mafia is not a term of endearment. And then they say, and it matters not whether some may call us that. Well, my lady, it does. It matters when Mr. Mashatile, who's the Don of the Alex Mafia, self-described, in the Financial Mail says, well, we're the Alex Mafia. And he owns that claim. He owns it, my lady. He doesn't disclaim it, he owns it. And so there's no denial. He doesn't find it problematic, Mr. Mashatile doesn't. And my lady, with respect, I start with that, because if that's so, and the people who are members of that, and the ANC itself describe these individuals as the Alex Mafia, then my lady, not only is that a description of who belongs to the particular grouping, but that they call themselves and are understood to be that term that is now taken great offense at by the applicants. So there can't be anything problematic with the term when they themselves see themselves as so described. And my lady, in respect of that point, it's then game over with respect to our learned friends. It's game over because a reasonable reader
That's the objective test. It's not with respect to what's said in comments by subscribers who may or may not recently have become members of News24. That's not the test. The test is what an objective, reasonable reader understands this term to be. And one gets the best sense of an objective, reasonable reader's understanding of that term from the Don of the group, who is interviewed in the Financial Mail about what it means, and he says there's nothing illegal about it, it's a political term, and he owns that term. So, my lady, you know that on defamation, our learned friends cannot make out the case. And my lady, therefore, it doesn't make any sense for you to be troubled with all this litany of explanations as to what the term mafia means, whether it's by reference to the Stellenbosch mafia or the taxi mafia or the construction mafia. That's irrelevant, because you know that the person who's described as the Don of this mafia that's relevant before my lady, the Alex Mafia, claims it, owns it, and doesn't for a moment suggest that there's anything illegal about it. So, my lady, that's just by way of opening.
Before you move on,
Yes.
where do I find a response to, a square response to, they call themselves that, as stated in the founding affidavit?
You don't get a square response. It's in the reply. It's at 01-388. If you look at 01388, my lady, you'll see paragraphs 70 and 71 of the replying affidavit. And they are responding to, you'll see the heading, paragraphs 60 to 69, and paragraph 63 in particular, it's said in hyphens, in parentheses, I should say. And then you'll see, well, it matters not whether some may call us that. I've already said to you, well, it certainly does, because Mr. Mashatile, who's a member, calls them that. And then they say at 71, I've been advised that absent an order admitting hearsay evidence, the respondents may not ordinarily rely on the evidence of confidential sources in proceedings such as these, and certainly not for the purposes intended. So, my lady, two things to say. This is an urgent application. They brought it urgently. Of course, we can rely on what we can in an urgent application, and the confidentiality of the sources is well understood. My lady simply goes to read His Lordship, Mr. Justice Sutherland's judgment about the importance of confidential sources to the media, and you'll know all about that. So, of course, we can rely on confidential sources in an urgent application. But, my lady, secondly, they don't do the obvious thing. They don't expressly deny that they are so-called, or that the ANC has so-called them that, or that the members within this grouping call themselves that, or that Mr. Mashatile calls them that. They don't do it. My lady, our learned friends, well, let me put it differently. The applicants are represented by two counsel, and if there was a direct challenge, they ought to have directly rebutted it. They don't. So, my lady, that is just by way of opening. Now, we'll get further into the detail of whether this term could ever be defamatory, or whether there's ever a defense that could be raised in response to the suggestion of it being defamatory. But in my address, my lady, I want to first, if I may, I want to highlight what I say by way of introduction are 6 fatal flaws in this case. First flaw is this. Our learned friends never confront the case law that shows that a pre-publication ban is a very, very serious invasion of media freedom. Our learned friends' best answer to that is to say, well, we're not dealing with that because we're worried about republication. But his entire case for urgency is about how they were worried about there being these escalated statements, and that they therefore needed urgently to get to court. Why? To stop them from being published. That's sophistry to suggest that that isn't a ban on publication, because there might have been previous publications to this effect. Well, that's a ban. That's a pre-publication ban. And so that's the first problem for them. The second problem is, my lady, they rushed us to court for a gagging order that was remarkable in its breadth. They wanted to interdict News24 from publishing any allegations contained in the 2007 Mail and Guardian article by Mr. Besson. not only by Mr. Besson, but also by Mr. Brummer, who was a co-author. And they deliberately didn't cite Mr. Brummer or the Mail and Guardian. They now in reply say, well, that's because they didn't have an interest in the case. But with respect, that's just palpably wrong. The statements that they complained about in their original Prayer 2.2 before they abandoned it, remember, they wanted and ordered that those unsubstantiated allegations not be repeated. That was what they wanted. Where did those unsubstantiated allegations reside, my lady? In an article in 2007, written by Mr. Besson and Mr. Brummer, and published not by News24, but by the Mail and Guardian. So the effect of that gagging order would have been to stop News24 from continuing to publish those allegations. That's the important point, my lady. They're not innocuous allegations. They've fallen by the wayside now by our learned friends' attempt to amend their relief. But their case squarely originally was those allegations were what they were worrying about. And those allegations are serious ones for them because they are raised in the context of business connections and contracts awarded to Mr. Mashatile's friends at a time when he was the MEC for Housing and the MEC for Finance, and the applicants were appointed as his friends, as his close friends, to senior positions in his administration. And then the three of them, together with others, orbited each other in businesses together. Those were the allegations at heart, and that there weren't proper tender processes that had been followed included. My lady, those are the allegations that we were rushed to court for. But I just stress here, that gagging order, had it been successfully obtained, would have meant that no longer would my lady or me or anybody else who reads News24 be able to know anything about those allegations. No journalist would have been able to publish anything about them. The learned friends now say, well, they're only worried about any nasty stories today about them and Alex Mafia. Well, they've not only amended their relief, my lady, now they're trying to amend their amendment because they recognize that there's a further problem with the breadth of their relief. So the original relief was overbroad. They try to fix that. We'll explain why they're not entitled to fix it, and my lady should not permit the amendment. But in oral argument, after my lady pointed out the breadth of what the amended relief would effectively mean, my learned friends recognize that there's a trouble there, and he's proffered to amend it even further to try and curtail it. My lady, this just confirms that this is a case where breadth, the gagging nature of that breadth, was on full display for my lady in the original 2.2 and the way that the case was constructed, and it remains in the way that the order now is pretended to be amended, and it is an abuse with respect. The third problem, and it's a fatal flaw as well, my lady, is that having had their deliberate overbreadth exposed in the answering affidavit, they've now tried to amend their notice of motion to abandon that most serious relief. My lady knows that. But that is the relief on which their case was founded and their pre-litigation demands were based. Our learned friend says, no, well, it's just a case of A and B and we now only want B. No, it's not so. It's not so. My lady, we have set it out in our, I think it's in our heads of argument. I think I'm doubly sure of this, but let me just make triply sure. My lady, that in this case, we were brought to court on the basis of allegations in the filing affidavit, and my lady will see this. Let me take you quickly to the filing affidavit. In fact, that's probably the best way for you to see it. If you have a look at the filing affidavit, paragraph 14. Paragraph 14, it's at case lines 01-11.
Yes.
My lady, you will see. What is this case at its core? At its core, this application seeks to interdict the first to seventh respondents from repeating unsubstantiated, unproven allegations. That's the very language of Prayer 2.2 that they've now abandoned. About Mr. Maile and me that identify us as core members of the so-called Alex Mafia. These allegations those same allegations. Where do you find them? They're contained in the following publications. What are they? Impugned publications, they describe them as, my lady. Impugned. They're impugned before my lady. And they include, right at the outset, an article authored by Mr. Besson, the second respondent, titled The Silent Power of Paul Mashatile, on 22 August 2022, and then a whole range of other articles, my lady. And they later explain, if you'll go with me, my lady, over the page at paragraph 17, 01-13, case lines 01-13. You'll see, they say, the impugned allegations, there's no debate, my lady, it's not about whether they're called Alex Mafia or not. The impugned allegations are the ones that they say they are concerned about, the unsubstantiated and unfounded allegations about their business connections. That's what they were worried about. They had their origins in an article published by Mr. Besson on the 31st of August 2007, titled Mashatile and the Alex Mafia, published by the Maile and Guardian. Just let me pause, my lady. It's astonishing to see immediately there that they're in a non-joinder problem. Because they say the article's published by Mr. Besson. But it wasn't only by him, it was by Mr. Bridgman as well. And of course, there's the significant and obvious problem that it was published by the Maile and Guardian, not by News24. My lady, they go on, and I won't belabor this point, but if you read the affidavit, just have a look at, for example, paragraph 19. Insofar as the original allegations are concerned, the 2022 August 2022 article added nothing new. Mr. Besson appears to have been unable to do anything more than do what? Rehash those allegations that still remain all these years later, both unsubstantiated and unproven, the very language of what you find in 2.2. So, my lady, you can read the rest of their affidavit and you can see that that's their theme. Lady, it's not just the theme as to what was in the filing affidavit and what we thought we had to respond to as the nub of their case, the core, let me use their word to be more accurate. Lady, it's also what we saw prefigured the litigation. So our learned friend read from some of the letters by his attorney, Mr. Pariachi, but if you go to, as an example, case lines 01-108. This is a letter from Mr. Pariachi to my attorney, Mr. de Klerk. It's FA12. Our learned friend read from some of it, but he didn't read this portion, I don't think. And it's paragraph 5. My lady, I'm just checking that you're with me, Anna.
I am.
Okay. 01-107, paragraph 5. This is now what they're complaining about. They say, what's clear to us is that insofar as our clients are concerned, the piece does little more than seek to resuscitate and amplify, there you see it again, unsubstantiated and unproven allegations published by the Maile and Guardian in 2007. And then, paragraph 6, what's very clear both to us and our clients is that your clients appear intent on continuing to publish these 16-year-old unsubstantiated and unproven defamatory allegations as if they're established facts. And then, the kicker, my lady, at paragraph 7, in case anybody was confused about what their concern is or their case was, they say, and that is our client's concern. So, my lady, we know why we came to court, we thought, until we realized that there were incredible difficulties with the case, and not least of all non-joinder, and that we pointed out, had a fatal urgency problem because these unsubstantiated and unproven allegations had been published since 2007 in various other publications our learned friend read to you from the chronology. They'd never done anything about them. And so, my lady, faced with that problem, non-joinder and urgency, they try to remedy their case. In fact, the case was moribund, it was dead by then. They try to revive it. So it's not a case of them being kind to everybody and being polite and, well, really, we're just trying to be clearer about what our case is. They're trying to fix a fatally broken case, which we would have been entitled to ask my lady to dismiss on that basis alone. Non-joinder, no proper urgency explained. So, my lady, they've tried to shift the goalposts, but in doing so, they've caused significant prejudice to us. So that's the third fatal flaw. The fourth fatal flaw, my lady, is this.
Mr. Duplessis, I know you wanted to get that in before the lunch adjournment, and I've given you almost 10 minutes extra.
You have.
So you've got the 5 minutes I took to fix my laptop, plus some interest on that time.
Yes.
I'll reconvene at 2 o'clock.
Thank you, my lady.
Court will adjourn.
Number 13, continue the acting with precision of Johannesburg. Case number 7-075-006.
Lady, apologize to appear. Aware as of yesterday that the matter will be heard by Khan AJ. Unfortunately, we were compelled to bring the petition for recusal for reasons stated and granted.
All right. So now, I understood that you weren't available tomorrow.
That is correct.
And this is the urgent court. I attempted to accommodate your availability, but you will now have to do one of two things. You'll have to pass on tomorrow's brief or this brief, but I'm going to hear the matter tomorrow. So the matter is then, I'll at some point tomorrow, the other things as well, but I will deal with the matter. So I'm sorry, Mr. Sithole, but...
I understand. My side, I may try to do our way down, but I need to explain to them. So if the matter may be a bit later, would that be appropriate?
What is a bit later?
I should know my status by 12
By?
12 p.m. 12, noon. By noon.
You should know whether... Well, no, that is not good enough.
I said, no, it may be had by noon. So.
All right, the matter can stand until 11:30 tomorrow.
Stop this.
So it's after tea. Mrs. Hutton, does that, can you be here tomorrow at that time?
I will be here tomorrow.
All right, so I apologize that you came today and that you were not heard. But you know the reason why. So maybe you'll see Mr. Sithole tomorrow, maybe not.
Stop this.
Yes, Mr. Duplessis.
Thank you, my lady. I was taking you through what, with respect, said were 6 fatal flaws in our Leonard Friends case. I dealt with 3. My lady, the 4th is this. And we'll elaborate on this, obviously, a bit down the line, but they abused this urgent court in multiple ways. They've got alternative remedies. They've rushed us to court with 2 days to prepare an answer. It's not correct to talk about a week that we had to answer. We were given 2 days to prepare an answer on the timelines out of the notice. And they'd sat on these allegations, first published in 2007, and at best for them that had been repeated in August 2022. So, my lady, they allowed these attacks on their reputations without doing a thing. And importantly, they built their businesses during that time, seemingly unaffected. You see in their heads now a complaint that you need to urgently bestir yourself, my lady, in order to help them in an urgent court because their businesses are otherwise going to be affected. Well, over all that time, my lady, they built their businesses seemingly unaffected by these allegations which had been out there and had been repeated. My learned friend Mr. Berger went through the chronology of how many times it had been repeated. And they've only bestirred themselves, my lady, when their close friend, that's their words, began attracting media attention because his political aspirations hotted up in the lead up to the ANC elective conference in December last year and then into this year. My lady, the 5th fatal flaw is this. Their targeting of News24 is as chilling as it is revealing. My lady, their reputations, which they've historically never sought to protect, will not be protected by this interdict that they seek. And that's because other media houses will continue to publish. A learned friend even said, well, they're only interested in Netwerk 24 and News24. Well, what about the Burger? It's within the fold. Apparently that's error. So, my lady, they are wanting a targeted gagging. And they say in their heads, well, and Mr. Berger himself, I learned a friend, said in oral, well, other media houses, if my lady grants the interdict, will sit up. And they'll be worried about publishing if there's an interdict granted. Well, that's the definition of a chilling effect, we say. That just proves the motivation behind the application. And my lady, I'm going to speak about this in more detail later. We say this has a slap suit written all over it. And 6th, my lady, and finally by way of a fatal flaw, is this comes at a time of political importance for their close friend, Mr. Mashatile. That's important. Not only because of the relief, which will then effectively be final, my lady, This is the time to report on Mr. Mashatile and his close friends and their business associations from the past when they were all in government together. This is the time. And my lady, they want that interdict now. My little friend was talking about how, well, he knows it may take some years before the trial gets underway. Well, that would mean that the interdict stays in place over that period of time. The critical period of political reporting that not only my clients, the media, have a duty to discharge, but that the public have an interest in receiving news about, my lady. And that's important because of another reason. The applicants have ironically drawn attention upon themselves by bringing this case, my lady. They moan in reply that since they brought the case, there's been media attention heaped upon them. And they, ironically, in reply, they saddle that up to try and argue for urgency, which of course needed to exist when they started the case, not midway through it. But my lady, why are they surprised? Obviously there was going to be media attention brought upon them by their efforts to reference allegations that had been published about them in 2007 in a court case that they're then attempting to gag those allegations being republished. So, lady, they should have expected that the effort by them urgently to gag the country's largest media outlet would generate media attention, not only on their court effort, obviously not only on their court effort, but on what it was that they were trying to suppress through their court effort. Now, my lady, that's not just because they are in the public interest as the applicants. It's also because, as I say, at this time, it's their close relationship with Mr. Mashatile that is in the national public interest. So they brought a case and they put themselves firmly in the national spotlight. My lady knows the Streisand effect. My lady knows it well. We're going to be calling what our learned friends' clients have done the Mashatile effect. By coming to court to gag news about their associations with Mr. Mashatile, they have deliberately, even if only inadvertently, drawn attention to themselves. They've only got themselves to blame. That doesn't make their case urgent, I'm going to stress. That doesn't make their case urgent. What it does, my lady, is it counts as a massive own goal. They now have drawn attention to an article that was written 15 to 16 years ago. They put it squarely back into the spotlight. They've done so by attempting to suppress those allegations. So now the public wants to know, well, what is it that they're worried about? Why don't they like these allegations? And they've done so, my lady, in a manner which suggests that quite by themselves, they have Streisand affected themselves, or Mashatile affected themselves. And my lady, with those 6 introductory points, let me turn to what I'm going to argue. The bulk of it will be by me, and a focus topic will be by my little friend, Mr. Winks. I'm going to be dealing with the following topics. As a framing point, my lady, and really I'm going to go through them in a, I hope, cursory fashion because you've got our heads. I'm going to be explaining as a framing point, firstly, that prior restraints on speech are invidious. It's a framing point because we say that impacts much more broadly. It impacts on the abusive nature of the case that's been brought by the applicants, obviously in relation to their original attempts to gag egregiously and too broadly, but it also highlights why they don't come close, we say, my lady, to meeting the balance of convenience test for an interdict. My lady knows in these types of cases the balance of convenience very often does the heavy lifting. Well, in this case, it's because they, our learned friends and the applicants with respect, haven't given enough attention to the case law on prior restraints, that they haven't come close to appreciating the very heavy balance against them on the balance of convenience test for the interdict they seek. So that's the first framing point. My lady, I'm then going to turn to why the case isn't urgent, and I'm going to say something very briefly after that about why the amendment, flowing from the lack of urgency, is impermissible. And my lady, I'm then going to deal with the balance of convenience very briefly as a lead-in to what Mr. Winks will say. I'm going to end by talking about why clearly this was an abusive effort at approaching my lady directly and urgently, because there are adequate alternative remedies not properly explained as to why they weren't used, and why we say this is a slap suit in effect, and even if not in name, and they should pay punitive costs. My lady, let me stress, before we get into each of those points, that the respondents are not afraid of the merits of a defamation case. We are asking simply for time, as the case law shows, to put up a proper defence. We're entitled to that. We've got a perfectly good defence. But the way that we've been rushed to court means that we have been limited in that way. We're not afraid of the merits at all. What we're asking my lady to do is to deal in your judgment with respect with each of the procedural points I'm going to come to, questions of urgency and abuse and so on, through the lens of prior restraints on egregious violations of media freedom. And we're going to ask you to write a judgment on those procedural points, my lady, because of the substantive protections that will flow from any such judgment, so that any future conduct by applicants or similarly situated litigants will be met by my lady's judgment. And we're also going to assure you, my lady, that these abusive efforts are particularly egregious precisely because the case for defamation is so woeful. My lady, it's so woeful because, as my learned friend Mr. Winks will detail, clearly Alex Mafia is protected comment. And in any event, my lady, the term Alex Mafia is not defamatory. And he will explain that to you in a moment. So, my lady, let me kick off with prior restraints on speech being in videos. You'll have read this in our heads, and I certainly won't take you through that. But what's striking about what we say, my lady, about all of that case law, is there's not a word, not a single word in our learned friends' heads about the case law on prior restraints. They don't deal with it. That failure, my lady, is regrettable because the position in our law is emphatic. And it frames not only how misguided the applicant's case is with respect, but also how abusive. The best that our learned friends can do on the case law, having abjured any proper engagement with the case law, is to tilt at a windmill with respect, because they tilt at the McBride case. They try to seek refuge in McBride, but McBride is dead against them. McBride, as you'll know, sued the Citizen because they had referenced the Constitutional Court was clear. You're entitled to rake up the past. When are you entitled to do so? When that person is vying for an important public position and what that person may have done in the past then becomes clearly relevant to whether they should occupy that position. And so the same is true in this case. Hard as they may now wish to distance themselves from Mr. Mashatile in the past, they cannot do so. They're an integral part of his past. And we know that they, to this day, claim to be close friends. They say that. Those are their words. So, my lady, the McBride case doesn't help our learned friends. But most importantly, what we want here is for my lady to, with respect, accept that this is not just a case about attempting to interdict your neighbor from saying bad things about you. This is a case about interdicting the media. So it engages a Section 16(1) right. And my lady knows that there's a Section 16(1) right that by definition allows freedom of expression and specifically includes freedom of the press and other media. And that right entails a corollary obligation. Why are you, as the media, entitled to that freedom? To ensure that everybody in this room and outside this room, in the public, gets to receive that information. And my lady, that is why, with respect, it is risible if you just think about the applicant's relief that they now want in its amended form. Effectively, they want to be anonymized. They want to be anonymized. So you can write anything you want about Alex Mafia. Just don't mention us. That's their relief. Any reporting by these two agencies, News24 and Netwerk24, simply mustn't mention us. But my lady, with respect, they cannot be anonymized. They're not children who get that protection under our media law. They're not sexual violence survivors. And just think about the ridiculousness of this. If they were to get that order, it would mean that newspapers could say something along the following lines. Mr. Mashatile had questionable business links with officials in his administration who profited from tenders coming out of that administration. But we cannot name the officials. That's the absurdity of it. Not only that, my lady, let me just give you the further utter absurdity of the relief. The absurdity of it is this, that you may not mention in any reporting about Alex Mafia. That would include, obviously, comment. So you can't interview somebody and say, well, what is your view about it? And that person who may well know exactly what happened there says, well, I know these individuals and they're all part of the Alex Mafia and this is etc. and this is how they work. You wouldn't be able to mention the applicants in that context, even if that person said that they were part of the Alex Mafia. Let me take the absurdity to its logical conclusion. If the financial Maile interviewed Mr. Mashatile after this order had been granted by, and they said, Mr. Mashatile, is Mr. Sithole and Mr. Maile, are they your friends and are they part of the Alex Mafia? And he said, yes, they are. We've been friends for years. We're well known part of the Alex Mafia. That point would not be reportable because of the gag that they'd have got. Even Mr. Mashatile's claims about these people would not be something you could report on. That's how absurd the relief is. That's how broad it is. So, my lady, the mountain that our learned friends would need to climb for the relief they seek, we say, is Everest high. And we know so from our highest courts. We've given you all the judgments. I'm simply going to remove what Justice Cordier said in print media, because it just captures it. And in print media, to the extent that you want to write a reference, my lady, it's in our heads.
No, you quoted him.
Yeah, that's a paragraph 10 of our heads, case lines 04-91. And, my lady, he was quoting from a Court of Appeal case where he said this. He said the prior restraint of publication, though occasionally necessary in serious cases, is a drastic interference with freedom of speech and should only be ordered where there is what? That's the test. A substantial risk of grave injustice. Not just a risk of injustice. A substantial risk of a certain type of injustice, a grave one. My lady, we've also cited His Lordship, Mr. Justice Sutherland, the DJP, in Mazzetti earlier this month. And you'll know that he said a South African court shall not, an injunction, shall not shut the mouth of the media unless the fact-specific circumstances convincingly demonstrate that the public interest is not served by such publication. And he went on in that judgment, lady, he was saying this, quoting in the judgment in Mazzetti, he was quoting from MIDI TV, where the SCA said as follows, and he was quoting paragraph 20 of the SCA, and you would have seen this in our heads, case line 04-92. It says, the SCA said, where it's alleged, for example, that a publication is defamatory, but it has yet to be established that the defamation is unlawful. Let me pause. That's exactly our problem, my lady. We've been rushed into an urgent court. We want the right to be able to properly prove that it is a offence. We've been denied that opportunity meaningfully to do so in an urgent court. But as he points out, where it's alleged, or as the SCA point out, where it's alleged, for example, that it has yet to be established that the defamation is unlawful, an award of damages is usually capable of vindicating the right to reputation if it's later found to have been infringed, and an anticipatory ban without being necessary for that purpose. So, my lady, the case law is dead against our learned friends. The courts have set a very high threshold for when you will grant this type of interim interdict. And they made it clear that there is a constitutional balance to be struck, and that that constitutional balance needs carefully to be considered by the court, and you will not upset that balance. You will not deny the media and the public the right to freedom of information and to receive that information, unless there is a very high standard that's met, in the word grave injustice, because it is an otherwise drastic interference. Now, my lady, we stand by all of those cases, and Mr. Winks will show you that we have a more than sustainable defence. So even on this basis, urgently rushed here, we can show you we've got a sustainable defence. But the simple point is, I'm asking us all to articulate that defence and allow a court to think about it carefully. If this case, for example, as my lady pointed out, had been brought in the ordinary course but on an expedited basis with the DJP allocating us for hearing, even if it was in October, we would have had a proper opportunity to raise that defence motion. We've been denied that opportunity, Melanie. And so, even though we have been denied that opportunity fulsomely, we still, in any case, on these papers, show that there is more than a sustainable defence in the form of truth and public interest. Not just that there's a sustainable foundation, my lady, laid for the particular publications, but in fact, an undisputed and indisputable foundation. Why do I say that? Because, my lady, our learned friends, 2.2 substantiated unfounded allegations, the core, all of that, that's been abandoned. So they're not seeking to have that in the contract that flowed from positions when Mr. Mashatile was MEC for Finance and Housing, and how the applicants were part of that inner circle, having come from the Alex background that they did, that the ANC calls the Alex Mafia. All of for defense, because they no longer dispute those facts. But before I even get there, my lady, I want to stress that the mountain is so high for the applicants for another reason. There's a very high threshold for an interdict against speech, precisely so that clients like mine, and journalists like mine, clients I should say, are entitled to not only prove their defense meaningfully, but get the benefit of the truth-finding facilities at trial. You're entitled to cross-examine, to discovery, to subpoena, to support your defense of why these facts are in the public interest. And my lady, and of course, there's the separate point made by MIDI TV and other cases, which is that, of course, the applicants have got an alternative remedy in the form of damages. So we say that they failed to meet all of these thresholds. They don't, with respect, confront the true legal test that my lady knows governs these types of proceedings, where there is an attempt to gag pre-publication. And as I've already started right at the outset by telling you, my lady, it really is sophistry to suggest that, oh no, we're just wanting to stop the publication of that which was previously published. No, my lady. Our learned friend himself said, they are urgently before you because they're worrying about future harm arising from what? Future publication. What? Allegations about them and Alex Mafia. Have they already happened, these publications? No. They pretend that they are about to happen. So what are they seeking? An interdict to stop the publication. Only in respect of News24 and Netwerk 24. So that it clearly is a gagging of a pre-publication nature. Well, lady, let me turn then to the next chapter, and that is the abuse of the urgent court. And I'm not going to bore my lady with the case law you know well. The Constitutional Court has told us that approaching courts at the 11th hour, extreme pressure on everybody, including the respondents in the courts. It results in courts having to deal with difficult issues of considerable importance under compressed time limits. That could be written about this case. That the Constitutional Court said in a party. Exactly the same applies here. Important issue. Apparently the applicants think that it's only their rights that are important, their reputation that needs to be considered in that conspectus. That's not so. It's also the respondents' rights. It's also the courts. And my lady, in that context, the courts have been particularly clear and pronounced on the following principles. I'm extracting them from what we've said in our heads. I'm not going to read them, my lady. You'll know that our heads at case lines 04-97, paragraph 28 on, deals with it. But my lady, here are the principles extracted. If you're seeking an interlocutory interdict pendente vitae, then you've got an even heavier burden to discharge on urgency. It requires, says the courts, maximum expedition from an applicant. The second point is, if you don't do that, if you don't get out of the starting gates fast enough, then as His Lordship Mr. Justice Plaskett put it in the Molondeni case, self-created urgency is no urgency at all. Then you get the application dismissed for lack of urgency. And as the case law further confirms, It's an objective test. It's a question of objective urgency. The court, even if it thinks that your case might subjectively be urgent, asks the question objectively. Well, did you bring this case quickly enough? Or did you manufacture your urgency? And my lady, that is what Justice Rampire wrote in a case that we've also cited for my lady in Ledema. My lady, the case law is so clear that with respect, I can be brief, I hope, on why we say there are 4 insuperable problems on urgency for our learned friends. And we've really heard very little from them on urgency. They've back-ended their heads of argument. There's sort of a page and a half on urgency. Very little from our learned friend on urgency and argument, other than to say things sort of basically started hotting up. And therefore they started acting in around June. Well, my lady, the first problem with that argument, and the first insuperable difficulty on urgency, is that for years, literally years, the internet, which is where we read the bulk of our news nowadays, has been replete with references to the applicants as members of the Alex Mafia. And the applicants did absolutely nothing about it. They did nothing about it despite their claim, founding, being that the core of their case, their work, today, before they changed their relief, is that those imputed are defamatory. That was the core of their case in founding. They said they're defamatory, and we've given you in the heads the various places where that's been said by them. And with respect, our learned friend Mr. Berger gave you a chronology, and the chronology was particularly helpful because he highlighted how 2007 there was a Maile and Guardian article. Then 2009 there were articles. 2010, 2012, 2014. And my lady, he seemed to think that it was helpful to his case to say, but each of those articles have been published by different publishing houses. You recall, he said, yeah, but it wasn't by News24, it was by different publishing houses. Well, my lady, that harms his case. That confirms that this allegation, or these allegations, are widely spread, not only for those that happen to subscribe to News24, but beyond that, by all the other publications that Mr. Berger, our learned friend, says widely published on this aspect. So the reputational harm, such as there may have been, was widespread because of the differentiated publications by different readers. I try and read as much as I can, but some people only read the Maile and Guardian. Well, if they read just the Maile and Guardian, they would have known about this. Others only read News24. Well, they would have heard about it there. So, my lady, that means that this has been out in the open, on the internet, repeated all the time. Now, my lady, they recognized their problem on urgency, so they dropped their complaint about the 2007 article. They try to do so in order to shore up their case on urgency. But they still don't get out of the starting blocks because their grievance against the respondents then on that version dates back at least to 21 August 2022. So they've got an 11-month problem, just short of a year ago. When Mr. Basson's article, The Silent Power of Paul Mashatile, was published on News24, and there he named the applicants as members of the Alex Mafia. Now, my lady, in addition to that, you'll remember that our learned friend, Mr. Berger, referenced another article published in the Daily Maverick on the 7th of December 2022. So we've got 2 articles last year. No action taken against them. Both of those articles referencing the same allegations and the Alex Mafia appellation. And here's the important point. I wrote down my learned friend's words, and he'll correct me if I'm wrong. He said, those articles were written, I'm quoting him, in the run-up to the ANC's elective conference in December last year. Now, my lady, our learned friend's clients are not immodest youngsters. They're politically attuned. If they were worried about the December conference coming up, where their friend, their close friend, was about to be vying for various very important positions, some of the most important in the country, they would have been on high alert to know that there might be more articles written about this. As we know, there was an article written on the 21st of August 2022. Then there was an article written on the 7th of December 2022, and articles into 2023. My simple point is this. They could have been in no doubt that there was going to be an increased public attention being given to Mr. Mashatile, their close friend, and because of his political aspirations, any links and associations and business contracts and so that might have arisen in the past. So, my lady, the fact that the reference has been repeated more recently doesn't make the matter suddenly urgent. This allegedly defamatory material has been firmly in the public domain and has been there for at least 16 years and certainly at least for the last 11 months, as all of this attention on the ANC elective conference has hotted up. My lady, from August last year, at the very least, our learned friends, clients, if they wanted to stop this type of defamation, as they call it, they ought to have brought a case. And my lady, we've commended to you the reasoning of Her Ladyship Justice Tolmay in Mokate versus UDM. You would have seen that in our heads. It's at paragraph 36. And my lady, in that case, she made it clear, there it was just a 3 weeks delay, but she made it clear that the statement's been in the public domain for a significant time and the harm that may have been done has already occurred and the proverbial horse is bolted. And she went on to say she'll be able to obtain redress at a hearing in due course, as all other litigants in defamation matters do. My lady, our learned friend attempted to get around some of this in debates with you by saying, well, the language escalated in sort of June and July. And my lady put it to my learned friend, but wasn't the substance always the same? And my lady's, with respect, spot on, absolutely correct. Because if you go just to look at the financial, the articles by Mr. Besson, 22 August 2022, the substance was the same. So our learned friends complain about the fact that the language escalated, that there was now, they were described as, for example, the notorious Alex Mafia and the Mafia, the mafiosi and so on. Well, my lady, the substance, and if there was any defamatory substance to it, went well beyond the simple term Alex Mafia. It's what was said about the Alex Mafia, whether that was defamatory. And if you go have a look at 01-42, this is an article by Mr. Besson, and it's case lines 01-42. It's FA1. Lady, I'm just checking that you're there.
01-42.
Yeah, 01-42. It starts 01-41. Adrian Besson, The Silent Power of Paul Mashatile. This was the August article.
Yes, yes, yes.
11 months back. Well, lady, have a look at 01-42, for instance, under the heading Captured Agencies. Captured agencies. I would have thought that our learned friends would have also complained that was a defamatory statement, justifying getting into court. And you'll see, it says there, in August 2007, I was one of the first journalists to reveal Mashatile's role in a grouping referred to as the Alex Mafia. And it says, at the time, the central allegation against Mashatile was that he had captured, we didn't use the word back then, the agencies under his control by appointing his friends and comrades from Alexandria Township, where he grew up, to head crucial, well-funded Gauteng agencies like the Gauteng Shared Services Centre and the Gauteng Economic Development Agency. Lady, if that was going to be acted on, it's exactly the same substance. Alex Mafia associated with these particular moments of state capture, that word, agencies under control, benefiting from it. And if you go on, you'll look at the rest of that article, my lady. It speaks about the Alex Mafia story having stung and they couldn't make it go away despite efforts to ban the use of the term in the Gauteng legislature. You'll see that at the second last paragraph. Lady, so the substance has always been the same as far as urgency goes. If the substance is always the same, then they ought to have been in court already, at least after August last year. And my lady, go to the Maile and Guardian article, the fonts et origo, all these problems, the core of their complaint. That's 31 August 2007. That's at case lines 01-87. And you'll see, my lady, if you have got it open, you'll see Mashatile and the Alex Mafia. That's the Mail and Guardian article, the headline. My lady, you'll see midway down the page, The Alex Mafia is a reference to a group of former activists from Alexandria Township who have risen to positions of influence. Mashatile, Maile, Kakana, Bridgman, Sithole are at its core. And then it says, Maile is chief executive of the Gauteng Shared Services Centre, provincial agency that answers to Mashatile, and that awarded the tenders to Business Connection. And then it goes on. They are shareholders in Business Connection through the same vehicle in which Mashatile declared, but then disowned shares. They serve on the boards of these firms. Ties between the men include the following. And it goes on, my lady. It says the Business Connection. It sets that all out at the bottom of page 0187. And my lady, if you have a look over at 0188, under the heading, the Alex Mafia, it says, the story of Mashatile, Maile, and Sithole is one often replicated in South Africa, of how struggle connections have evolved into corporate contacts and sometimes contracts. And then the young men who fought in the trenches in the 80s now occupy boardrooms and positions of influence in the public sector. And then you'll see something that surely should have moved urgent proceedings, my lady, if the substance is the same as them. It says, although some see this as a story of people who pulled themselves up by their bootstraps to make good in the freedom years, a reliance on state tenders carries the risk of cronyism, more so when tender systems bend to who you know or to which struggle network you connect. Lady, it's a very simple point I'm making. Our learned friend says, well, the late language of June and July means things have escalated, but the substance, my lady, put to our learned friend quite correctly has always been the same, yet they only come now. So that kills them on urgency, with great respect. My lady, to the extent that our learned friends now want to claim that these new words, these new nasty words, have generated a new urgency justifying them rushing to court. Well, my lady, that, with respect, is also simply not so. Because what they've then done, and my learned friend Mr. Winks will highlight this, is they've killed their case on defamation. Because what it means is that before these new words came, my lady, like notorious, Alex Mafia was an innocuous term.
Mr. Berger was pained to say that he didn't concede that. He said, but if so.
Yeah, well, he doesn't need to concede it. It's enough for us to say, if he is right, that before these words didn't spur them into action to come to court. But now these words, these new attributes of the appellation, that they're the notorious Alex Mafia, as an example, are the reasons for them to come to court. Well, my lady, you can't have it both ways. Then it means that only now, with that extra addition, is a basis to get to court. My lady, so on either way, on either version, they kill their own case. My lady, and let me just make the final point on this. The fact that the word notorious, for example, is added to Alex Mafia really is not a basis to get into court. It doesn't justify urgency. Lady, the word notorious, I mean, my lady will know this, the notorious RBG, the notorious Ruth Bader Ginsburg, it doesn't suggest that anything about her is suddenly turned from good to bad. The word notorious simply means that it's particularly well known. So it doesn't help them either to try and add these further additions to what they claim is the basis to get to court urgently. So, my lady, the second problem with their urgency claim is that they've tried their luck troubling this court when they've not even attempted to obtain the speedy relief that they said they might try for at the Press Council of South Africa. My lady, now, this is not an alternative remedy point. This is an urgency point. And my lady, I don't need to make this up. It's the attorney's letter. Have a look at what the attorney's letter says. My lady, our learned friend read from it. It was FA8. It's at case lines 01-93. This was the 6th of July. And it's important, if I might ask my lady, just to turn it up.
I'll have it in front of me.
My lady, you'll see it starts. Dear sirs, defamatory statements and publications. We act on behalf, well, you will note, my lady, at that time they acted on behalf of 4 people. Sithole, Maile, Mr. Koza, and Kakana. Those 2 have since dropped out for whatever reason. They refer to the articles and so on, and then over the page, my lady, they say, paragraph, so let me remind you, you would have seen this letter previously. Our learned friend read from paragraph 9 of this letter, because that was what he said were the demands that were made of my client. But my lady, our learned friend didn't read for you paragraphs 4 and 10. Paragraph 4. These sensationalist statements are defamatory and fall foul of your journalistic duties as regulated by, what? The Press Code of Ethics and Conduct for South African print and online media. Amongst these transgressions, we advise that neither of our clients were approached for comment prior to the release of the publication. So, my lady, they brought the letter makes this clear. This is a violation of ethical codes as journalists under the Press Code. You didn't ask us before you said these things for comment. Then go over the page, my lady. Paragraph 10. Should you fail to comply with the aforementioned demands, our clients reserve their rights, amongst others, to inter alia, lodge a formal complaint with the press ombud. And you can read further. There's no mention of urgent interdicts. They were telling us they wanted to get to the press ombud. So, my lady, that means that they have bypassed that. They've threatened it. They said that's where they wanted to go. You're breaching your code under it, but we don't understand. There's no indication why in their finding affidavit they have simply decided to come straight to you. And my lady, that's the point. We're not suggesting that people can't come to urgent court. In certain cases, you may simply not be able to get to the press ombud in time, or you may decide that it's too important, the press ombud can't give me an interdict. I need to get an interdict. But my lady, if that's the position, you nevertheless need to explain to a court why, after your own attorneys in their letters have said, listen, we're thinking of going to the press ombud because you're violating that code, you've got to explain why you've chosen to bypass that for urgency. Because why? Rule 612C says, a party that seeks to approach an urgent court must set out fully the basis upon which they claim to be treated specially. So we say, my lady, this doesn't mean a litigant can never approach the urgent court. Obviously, there are circumstances that might justify it. But what it does mean, my lady, and that's what my lady held in Mabote versus Funduzi Media, is that a litigant approaching the urgent court should explain why they haven't pursued speedy remedies at the Press Council. So, my lady, the applicants in this case have attempted to give those reasons in reply. That's only because we took the point in answer, but they should have put it out in finding. And in reply, they unpersuasively say the following. They say they need an interdict and that that's not available from the press ombud. But they fell on all the other grounds of urgency that we've already explained. They weren't entitled to be here. It's not an answer in any event, because the relief that they say they were claiming is relief that entails the press ombud. My lady, again, I'm not making that up. Have a look at paragraph 9 that our learned friend read from. In his letter, it's 01-95. Our clients have accordingly, you said at 9, have accordingly instructed us to demand, which we hereby do, in mitigation of the damages. Yes, 1, immediately desist. Okay, so it's a desist order, and given undertaking that they'll desist, that was refused. But look at what they asked for next. A retraction of all references and an apology to each of our clients, prominently displayed about it. Where did they get that from, Maile? The Press Council. They know they can't get it from a court. Can't get that relief from a court. My lady pointed that out in the Mabote case. So they needed to get it from the Press Council, and that's what they said they would demand from us. So we were entitled to accept that that would be, at the very least, an appropriate place for them to go, especially when my lady knows that you can get speedy relief from the Press Council. And who's to say? I mean, they say, oh, we had to get an interdict. Why? Why is that so? What if they'd gone to the Press Council and the Press Ombud had said, look, no, you must issue a retraction and an apology. You shouldn't have done these things. Why would that not have been enough? My clients may have then decided, okay, well, we better issue a retraction and an apology, and that would have been vindication of their claim. And it would have meant, if my clients were to take legal advice on this, that they would at least have to decide whether they would continue, despite having had that finding by the Press Ombud against them, or the adjudication panel, whether they would nevertheless continue to make such statements and publications, and then face the risk of an interdict. But the point is a simple one. There was relief available. So, my lady, the second point is they didn't explain why they bypassed an obviously available remedy. My lady, the third point is this. This interdictory application is pointless to stop the harm. Not only because the harm's already occurred, not only because it's already occurred, but because it's going to continue to occur because they've not sought to interdict the publications by other media houses. So, in short, if I may put it this way, the applicants have not only self-created their urgency over years, it's also artificially manufactured urgency. They're rushing to this court for relief against my clients when all other media houses out there are not interdicted. And then fourth and finally, my lady, on urgency, the timelines. My lady, it's not correct to say that a reasonable period of time was given to my clients. This is a complex case, at least in the sense of having to gather the facts, trawl through the history as you would have seen. They brought us to court on effectively 2 days to prepare an answering affidavit. They launched it on the Monday, the 17th of July. You'll see this in the notice of motion, the original one. They gave us 2 days until Thursday, the 20th of July, to oppose. Not to draft an answering affidavit, but to oppose. And then, my lady, 2 days after that, so my clients would have had to get legal advice, figure out whether they wished to oppose, whether it was worth it, whether they shouldn't think about other alternatives. And then, after they decided to oppose, they gave us 2 days until Monday, 24th July to file an answer, in order to be in court for the 1st of August. My lady has already deprecated such timing in Mabote, where you referenced what His Lordship Mr. Justice Kachalia said in digital printers. In that case, my lady will recall that at paragraph 43 of the judgment, there too the application was served on the 22nd of October and the respondent was required to file an answering affidavit by Tuesday, the 27th of October. So exactly the same timelines that our learned friends say is reasonable for us. And my lady pointed out that this afforded the respondent 2 court days to prepare its answering affidavit, just like for us. And my lady said, as Kachalia J. said in digital printers, the urgent court is not geared to dealing with a matter which is not only voluminous, but clearly includes complexity and even some novel points of law. Let me point out, my lady, we don't think this case is necessarily complex because we think the answers are so clear on the law. But we didn't know that until we looked at the case. The complexity of it arose when the finding affidavit hit us. And we had to deal with it. We had to think about joint what it is that the applicants actually want from us, because their relief seemed so overbroad that it couldn't possibly be that they wanted that. And when we pointed that out in answer, it turned out we were right. That's the complexity of a case in an urgent matter. But my lady, not only is it complex, it also requires a delicate balancing by my lady in trying to decide this case, effectively a week later. Are there novel points of law? Well, we say yes, with respect. First of all, there's the question of whether this is a slap suit. I'm going to get to that in a moment. Or if it can be described as a form of slap suit against journalists. I think the question of the Mashatile effect is potentially novel. The applicants coming to this court, by definition, generating their own publicity for a case, which had last been published about in their version in 2007 as the core of their matter. And my lady, on this point, as my lady pointed out, on timing, had they just approached us, together with the DJP, for a truncated time period to be agreed, an expedited hearing could have been had, and their proper relief in due course that they might have sought, we might well have been in court before October. My lady, then we conclude on urgency by saying that we ask my lady to, because these types of cases should not trouble the urgent court, we say that applicants like this rush matters of this nature into the urgent court should be subjected to a judgment which explains why it is not appropriate. And so we've taken some time to go through urgency precisely because we should not urgently have been here. My lady, let me turn briefly, because it's related, to the question of another abuse, and that's the amendments. Not only have the applicants claimed urgency or generated it for themselves when there isn't any, Malay, but they've showed their hand by materially altering their case in reply. My lady, I don't need to remind you that as we stand here now, we still don't know what relief they actually seek, because our learned friends has offered to do some further amendments to his amendment. But what we can say is that initially, when this case was brought, for the reasons I've already articulated and I've highlighted through the attorney's letters, as well as what is said in various places in the finding affidavit, there was no debate. The core of their case was about those allegations, as they called them, the unfounded and unsubstantiated allegations, lying resident in Mr. Basson's article way back 16 years ago in 2007. Those allegations, as I said, were the core of the case, and that's why the relief they sought in Prayer Point 2.2 was aimed at those allegations. The Alex Mafia appellation, yes, they were upset about that 2.1, but 2.2 was about those core allegations, and they wanted those interdicted too. As I've highlighted, my lady, we filed our answering affidavit, and then everything changed. The amendment, we say, is impermissible, and there are 4 reasons very briefly for why. The first problem is it is a procedural problem. Their amendment is not brought in any application, and we've objected to it. It's not a nitpicking point. It highlights the original abuse of urgency problem. Had they brought this case properly, and had there been a sufficient period of time for us to consider it and answer it, there might have been a chance for there to be a formal and proper application for an amendment rather than one made by them belatedly in reply. My lady, the second problem for them is it's not something that just for the asking. It's an indulgence from the court. And my lady, we've highlighted for you that one of the considerations the SCA has said in Fed Group is prejudice to the other side. As the SCA said in Fed Group, we've quoted it for you, my lady, at case lines 04-95 of our heads.
What paragraph?
Paragraph 20. You'll see the final paragraph in that quote, which we would lift out for my lady. It says, furthermore, the case that CPT was called upon to meet was the transfer of the extensive area initially sought, and it marshaled evidence in relation to valuation and prejudice relative to that case. The ground has now shifted radically to CPT's prejudice. My lady, in what way had it shifted? Because you'll see Fed Group sought to amend its notice of the motion to cut out one of the areas that it was fighting about and only to focus on the remaining area. Exactly what our learned friend Mr. Berger said. No, but this is just a case of narrowing. We're going from instead of A and B to just A. Well, this is exactly what this case was about. And the SCA said, emphatically, this cannot be countenanced. The application to amend the notice of motion thus falls to be dismissed with costs. So, my lady, they brought us urgently to this court for particular relief. They based it squarely on those allegations in the finding affidavit. They called it the core of their claim. They had it Prayer 2.2, which they stressed was the relief that they sought in that respect in an interdict. And we have now shown that that is entirely unsustainable. And my lady, I will ask my lady to, in your own time, if you have a look, just to read our answering affidavit. I'm not going to take you through it now. I did it last night and I highlighted for myself in pink the various places where our answering affidavit engaged with their allegations relating to the 2007 article, the unsubstantiated allegations, and the relief they sought in 2.2. Our answering affidavit copiously deals with that. It raises the question of non-joinder, which was something we had to raise, and it highlights on urgency how their case is effectively one which they themselves have attempted to manufacture. So, my lady, of course our case was directed at meeting that case. So it's manifestly unfair and prejudicial, my lady, to do so and attempt to shift the ground in that way. We're entitled to demand that their case was dismissible because of the way they brought it, because they didn't have joinder properly articulated, because it wasn't urgent properly, and because the allegations that they wanted to interdict were so broadly and over broadly stated that it was an abuse. And my lady, on that basis, had we not had them amend in the way that they have scurried away in reply to do, we would have won on that basis. So we're entitled to insist that we still win on that basis. And my lady, we also are entitled for my lady to decide those points that are on that so that it can become res judicata against them. So that those aspects, for example, let me just say, around if you're wanting to impugn allegations in an article in 2007 co-authored by somebody, you must join that person. If you're wanting to impugn that person and that article, you must join the media house that published it. We're entitled to have that. Because, my lady, our learned friends have said they only are focusing their interdict now against my clients. But everybody else out there will be chilled, will be noticing this. We'd like a judgment that says you're not entitled to try and chill on this basis. If you want a judgment against Network 24 or News24 in respect of allegations published in other newspapers, you must join them. Otherwise, your case is dead in the water. So, my lady, we're entitled to ask for that from the court. My lady, third, very briefly, the amendment should not be permitted. Our learned friends suggest that they're trying to really just help us all by narrowing the case. But no, my lady. They have, not they, but their clients, have been exposed for an egregious abuse of constitutional rights. Because the effect of the intended amendment is to abandon that very wide ban on repeating the contents of the 2007 Maile and Guardian article. Not just any contents, my lady. Public interest, critically important contents about the connections between Mr. Mashatile at a time when he, together with what he self-describes as the Alex Mafia, were friends, and he appointed them to government positions. They won contracts, and he's got business relationships with them. That is the type of information that the two prayers sought to gag. And, my lady, with great respect, that is an egregious attempt at publication. Banning.
Canvass this with you. So there was the original, or there is the original notice of motion.
Yes.
If one postulates that the court then, or me, that I refuse the amendment,
yes,
then the original notice of motion stands. But Mr. Berger has expressly abandoned seeking the relief. He says, we're abandoning that relief.
Yes.
So I refuse the amendment, and it's not as though the original notice of motion revives because they've abandoned the relief. And doesn't that put one back into the position where where the amendment's granted?
My lady, I think there are two ways to deal with it. I see the difficulty. The one, my lady, is to say, well, the amendment isn't granted, so they stand and fall by their original application and what we've answered.
Yes.
And they can't try and fix and reply. Therefore, their case fails in respect of 2.2 and 2.1. Alternatively, my lady can say, well, let the amendment wash in, because he's expressly abandoned that. But one can't close one's eyes to how this happened, and one writes a judgment then that speaks to how this happened and says that even though the amendment effectively had to be allowed because of the abandonment, the manner in which it was done created these difficulties, and therefore a comment is cast upon that. I think those are the only two ways in which it might be dealt with. My learned friend, Mr. Winks, may think of a third or fourth even, but I'll wait to see. But I think on my feet that's hard to do. My lady, the fourth problem with the amendment is this. It's calculated to avoid or evade the penalties that befall an abusive process. Because when you abuse a process and you seek something that's not allowed and is overbroad, particularly in this type of case, then the ordinary result is that it is struck or dismissed with punitive costs. And that's why I'm saying I want to keep alive the option for a court to write with respect to judgment about that aspect. And so,
sorry, just to repeat, it was designed to avoid?
To avoid the allegations that I've been making about how originally their case was an abusive process. The way in which the relief was sought was so overbroad and against the Maile and Guardian and against Mr. Brimmer, but without them being cited effectively, that in and of itself was an abuse, and we would be entitled on that basis of sneaking an amendment at the end once the shoe began to fit a bit tightly for them. So, my lady, that's on the amendment. Lady, if I might turn then to, very briefly, the balance of convenience. And this is a prelude to what Mr. Winks is going to be able to say to you about defamation. And I can be accordingly brief. We've already explained the Everest high mountain the applicants are going to climb to obtain an order for pre-publication banning or gagging. And as I say, Mr. Winks is going to explain to you that there is a plausible basis for a defence of public interest, and in any event, the allegations aren't defamatory. But, my lady, I want to explain to you why on the test for pre-publication, remembering I said that it's a framing principle, I want to explain to you why the applicants don't even get out of base camp. And that's so for 4 reasons. First, they haven't produced any evidence of prejudice, let alone what Justice Squeer, quoting Lord Scarman, described as grave injustice. So the prejudice to them, my lady, we say, if it's refused, is precisely none. They'll be in the same position they've been in for 16 years. And that's by their own election. So their reputations, such as they may be, will be in no better or worse position if the interdict's refused. And any prejudice they may suffer is because they didn't previously try to stop what are substantively similar allegations way back in 2007 at first, and certainly at best for them in August of 2022. And my lady, we've quoted for my lady's benefit, my lady, from Mabote versus Fundudzi Media, where you have explained something similar in that case, where you said, and I'll just read it for you, no action has been taken by the applicants against Opera News or any of the other publication. There seems to be no merit. There seems to be merit in the argument that whether this court grants the applicant the relief she seeks or not, her reputation will not undergo any material change, for it's already what it is, and the publications above listed have seen to that. And courts are not inclined to grant orders that have only academic effect. So, my lady, that's the first problem for them. The second is, of course, that, or related to that, is that the applicants have the option of claiming damages in due course. If it's found that the respondents have acted wrongfully, and then those damages will be aggravated if there has been repeated by my clients. And that, we've given you the judgment with the authority for that. It's Mokate versus UDM. My lady, that has to be weighed up against the risk to my clients. The granting of the interdict, as I say, it's going to be effectively fine. It will interfere not only with their constitutional right to freedom of expression, indeed their obligation, but also the public's right to the free flow of information and ideas, no less about political issues relating to potentially their future president. I mean, how much more of a public interest weighing could you possibly get? This is a man who, we have shown you, my lady, may well be in the running for the President of the Republic of South Africa. These are the types of facts around which the public should be entitled to know more in order to make an assessment of whether he is worthy of that position. My lady, the second problem for the balance of convenience for our learned friends is that the relief, as I've already hinted, is final in effect. And we've cited for you the Hicks case from the Supreme Court of Appeal. And it's at paragraph 68 of our heads, case lines 04-08. My lady, I'm just going to read it for you because the last passage, it's paragraph 68. We've underlined the relevant bit for you, but I see we haven't underlined as far as we should have. You'll see there, the balance of convenience it's determined. It is at that stage that consideration should be given to the fact that the person allegedly defamed will, if the interdict is refused, nonetheless have a cause of action which will result in an award of damages. This should be weighed against the possibility, on the other hand, that a denial of a right to publish is likely to be the end of the matter as far as the press is concerned. And in the exercise of its discretion in granting or refusing an interim interdict, regard should be had inter alia to the strength of the applicant's case. We say they've got no strength to their case. The seriousness of the defamation. Well, my lady, so serious is this defamation that they haven't acted on it for 16 years. Then the difficulty a respondent has in proving, in a limited time afforded to it in cases of urgency. That's our point. The defence which it wishes to raise, and the fact that the order may, in substance, though not in form, amount to permanent interdict. My lady, that's precisely the difficulty in this case. At a time when it is in the national interest, I can't stress it enough, that there be an attempt to allow as much reporting on these associations as is possible. My lady, the third difficulty on balance of convenience They can't meet the test of substantial injustice to them because on their case, by their case, they only try to put one finger in the dike. Because the granting of the interdict is not going to be effective in protecting the applicants from the alleged defamation. Why? Because it's not going to interdict all the other members of the media outside of those that are in this court. So the limited advantage to the applicants is thus not worth overriding the respondents' right to free speech. By their own failures in the past, and now in this case too, they've allowed multiple holes in the dike to develop. The stories about them flow freely and publicly, and they simply can't damn them by this case. And again, that point has been lucidly explained by Maile J.A. in UDM versus Lebashe. I'm not going to read it for you, my lady, in the interest of time. It's paragraph 70 of our heads, case lines 04-109. You'll recall that she said it would be a brutal fulman. The last passage you'll see says it relates to one of the requisites for an interdict, the balance of convenience. On this score, clearly did not favour the granting of an interim order. An interim order should not have been granted in the first place. So, my lady, these allegations, even if our learned friends were to win before my lady, would remain all over the internet. And they may be used by countless others. I suspect, my lady, if that my lady were to grant the interdict, it would exacerbate media publicity attention for our learned friends' clients. Other media houses would not be chilled, as our learned friends suggest. Certainly not where they thought there was a basis for proper reporting as it is. So, my lady, the fourth point against them is on balance of convenience.
You've got 1.2.4 points, and I'm losing the...
No, I said I had 4 points
you
on
did
balance
say
of
4
convenience.
points, but then you went back to 2 points. But anyway, I've got it sorted out. I think.
Maybe it's me, my lady. I went into law because maths wasn't a great strength, but it's possible that I'm...
No, I'm following you.
I think I'm on point 4.
You are.
My lady, they haven't instituted their action. Lady, their cause of action arose on their version, at least in August 2022. Remember, they talked about Mr. Basson's article. They noticed this article. They were upset about it. They say it was defamatory of them. Their reasons for getting to you today, my lady, is on an urgency basis. There was nothing stopping them launching their action for defamation way back then. Why haven't they? They still haven't, my lady. So, my lady, what is the difficulty? Is that, well, we just don't know what their cause of action is. We don't know how good or bad it is. They don't prove that they've even got a prima facie case. We can't attest it. Our learned friend says, oh, we've got a pretty good idea because, well, they've set it out in these papers. Well, we don't, with respect, my lady. Every time we take a point against them, they change their case. So we don't know what their case really is. We don't know how strong or good it is. They need to file particulars of claim, and then one would be able to know. Lady, there is one, with respect, we say this, reasonable, if not ineluctable inference to be drawn for why they haven't done that. They wanted to see what the media house's defences would be. And they can then adjust their case before they bring it. Finally, my lady, there are adequate alternative remedies. I shan't take you through that. It's the press council point. And we finish by saying that we, in this respect, say that for all these reasons, the applicant should pay punitive costs. We've set this out in our heads, my lady, and I've drawn attention to the fact, I've told my learned friend before we started arguing, that I would draw further attention to a judgment that I'd forgotten about, my lady. I ought not to have. It's Morn versus Zuma and others. It's a judgment recently in the full court in part of the world I live in, around slap suits and the question of whether the prosecution of Ms. Morn amounted to a slap suit by Mr. Zuma. But there's an important set of 3 paragraphs, there are more, but 3 that I'll highlight for you in that judgment. It's firstly paragraph 177, my lady. It's at case lines 04-1146. So we've got a full bundle of authorities. I don't know if you would wish for me to hand up a hard copy, because then you've got them all available.
Yes, please. Thank you.
This one. Yeah, my lady. Lady, if you go to right at the back, it's case lines 1146, right towards the back, I think. Paragraph 177 of the judgment.
Thank you.
My lady, you'll see there. So the full court was elaborating on the idea of a slap suit. And in that case, my clients, the Campaign for Freedom of Expression, had argued about there being a slap suit that had been involved, and Media Monitoring Africa had complained about there being a slap suit inherent in what Mr. Zuma had done in bringing his application against Ms. Morn. And my lady, the court elaborated on the debate about what these suits were, and it highlighted what the Constitutional Court had said in Mineral Sands. And you'll see at paragraph 177, sort of a midway down the paragraph, it's starting, the court embarked on an analysis of the origin of the slap suits in the USA and Canada, and remarked that slap suits were frequently brought as defamation claims. The primary aim of slap suits is not to enforce a legitimate right, but to silence or fluster the opponent, and are intended to silence critics by burdening them with the cost of litigation in the hope that their criticism or opposition will be abandoned or weakened. Let me pause, my lady.
So where are you reading from now?
My lady, that is from paragraph 177, and the court is quoting from what the Constitutional Court had said. I'm hopeful that that's right in my notes. Perhaps I should make 100% sure. 146. Sorry, my lady. So if you see 177, you'll see that that's at the bottom of 1146. The Constitutional Court talking about slap suit defences, and slap suits by definition limited public participation by reason of legal process. You got that, my lady?
I do.
And then you'll see the court embarked on the analysis of the origin of the slap suits in the USA and Canada. That's over the page, 041147. And remarked that slap suits were frequently brought as defamation claims. You can end there. Then the primary aim of slap suits, the next sentence, is not to enforce a legitimate right, but to silence or fluster the opponent. And then quoting from the Constitutional Court, this is the Con Court, they are intended to silence critics by burdening them with the cost of litigation in the hope that their criticism or opposition will be abandoned or weakened. The plaintiff does not necessarily expect to win its case, but will have accomplished its objective if the defendant yields to intimidation, mounting legal costs or exhaustion, and abandon its defense. So, my lady, first point to make is that's what a slap suit is intended to do. It's used very often in respect of defamation cases. It's intended to silence critics. Lady, our learned friends have told you that the motivation behind this case, even though it's only focused on News24 and Netwerk 24, is that other media houses will look up and will be on guard not to publish similarly. So it has that silencing or flustering effect on their own saying. Lady, have a look then at paragraph 185 of the same judgment, and it's at 041149. The theme continues by the full court. Slap suits have specifically been recognized as a means by which lawsuits are instituted to quash criticism and debate through litigation that's deemed an abusive process. Slap suits involving journalists are intended to intimidate and harass them and prevent them from reporting. And it's been a growing trend internationally and has been recognized by media bodies globally. Slap suits are not used to vindicate any right, but are used rather to silence journalists who are perceived to report in the public interest. My lady, and then paragraph 190, the last paragraph I asked my lady to turn up. 041151. Thus the courts have recognized that it is quintessential to the freedom of expression and freedom of the press to protect the abuse to intimidate, censor, and silence journalists by means of slap suits. Slap suits give recognition to the various international instruments where the attacks on journalists, specifically female journalists, have been recognized. The lady goes on at the bottom of that page at paragraph 90 to say, these are issues, and I can say this of my clients, the issues in this case too, on which Moore not only has a right
to report, but a duty to report on. Why? Because in Kamalo, the Constitutional Court said the following: it's the function of the press to ferret out corruption, dishonesty, and graft wherever it may occur, and to expose the perpetrators. The press must reveal dishonest, mal, and inept administration. I'd ask you to underline those words, because that's what those allegations are, my lady. It's about inept, maladministration in the Gauteng government at a time when Mr. Mashatile is alleged to have been involved, alongside his friends in the Alex Mafia, of being involved in precisely that type of conduct. So, my lady, we conclude by saying we, with great respect, suggest that this has all the hallmarks of a slap suit. And you just have to ask yourself this question: why was it necessary to cite anything beyond Media24 as the first respondent? Instead, we have the second respondent, Mr. Du Toit, and each of the journalists that are involved in the special investigation of Mr. Mashatile, all cited in their personal capacities. Originally, all were liable for costs. And interestingly, the only person against whom no relief is sought, milady, is the eighth respondent, not a journalist. So, milady, and there's no answer. There's no engagement with this problem by the Prince. So we say in those circumstances, with great respect, that this is a case which justifies punitive costs, and that we would ask for those reasons that the matter is dismissed. But before I get to say that that's the end of our case, Mr. Winks will take over, I hope, for a short, certainly shorter than me, just to explain why it's not defamatory anyway. Lady, may I just pause to say, and I beg an accommodation. I think I'm the only person that has to fly to Durban. And if I might be excused just after Mr. Winks, and no disrespect to my learned friends if I don't listen to the reply, but I'm in my lady's hands if that's...
Certainly. You don't have to be here. That's why they're to counsel. I don't think you can object, but do you?
No, I don't object, but I would like to offer a trade, and that is that I can get a 2-minute comfort break.
Yes, certainly. Court will adjourn. Mr. Winks.
Thank you, my lady. I hope to be very brief. Of course, subject to any discussion we might need to have. As my leader mentioned, I'll just be dealing with two discrete issues, which is whether Alex Mafia is defamatory and whether, if it is defamatory, it's protected comment. Now, it's become abundantly clear from our learned friend's address that Alex Mafia on its own is not defamatory. And it's, when one looks closely at the founding affidavit, it's not even properly pleaded as defamatory. Only the surrounding language is pleaded as defamatory, and that language is not hit by the interdict. So the applicant's counsel has made clear in his address that the 22 August 2022 article by Mr. Basson was not sufficient to represent court. Now, that was where there were references to Alex Mafia and the repetition of the 2007 Maile and Guardian article. And he tells us that it's only when additional words are introduced that the applicants start to suffer harm, which now they say will be irreparable if it's not stopped. Now, those words are not targeted by the interdict. So the applicants cannot claim an interdict based on those words being defamatory. They have to show that Alex Mafia, the only words targeted by the interdict, are defamatory on their own. And we see it's not only a concession made in oral argument. It was, in fact, one of the seeds of the application's demise in its founding affidavit to begin with, in paragraph 27, which is on page 01-17. What the first applicant says is, having been described as members of the notorious Alex Mafia gang, in quotes, and controversial tenderpreneurs who are engaged in corrupt business practices, then we decided to act. He's referring to the June and early July publications. These things, notorious Alex Mafia gang, controversial tenderpreneurs, don't appear in 2022. So, but in 2022 you have Alex Mafia, and in all of the publications in the 16 years prior to that. Now, to shore up their case, they then take us chapter and verse through these articles. And they say at paragraph 54 of the founding affidavit, which is on 01-26, they complain about various language, which again isn't hit by the interdict. And I'll take you to the language. So this is under the defamatory statements. The main heading is defamatory statements. So it's not a case about Alex Mafia on its own. Paragraph 54.2 on page 0126. The central allegation against Mashatile is that he captured... At the bottom, yes, sorry. Is that he captured the agencies under his control by appointing his friends and comrades from Alexandra Township, where he grew up, to head crucial, well-funded Gauteng agencies. That's not defamatory on their case. At least, well, they say it's defamatory in the founding affidavit, but that's not what they're seeking to interdict. The word Alex Mafia doesn't appear there. On the next page, 54.3, we were named as well as the agencies we headed. The allegation was clear. We only got the jobs because of our connections to Mr. Mashatile, and our role was to ensure that he improperly controlled the agencies. The article strongly suggests that such control was exercised for corrupt and or nepotistic purposes. But they don't plead that these meanings come out of this two-word phrase, Alex Mafia. This is from the allegations as a whole, these core allegations they talk about. So there's nothing in the 2022 article that they actually list as defamatory, which comes from the words themselves, Alex Mafia. It's from other words, it's from other language that they say they are defamed. Then in the next article, the News24 article of 26 June 2023, which is further down on the same page, the complaint is that here they complain that there are 2 gratuitous references to the Alex Mafia. But what we know about this article is that they're not named as members of the Alex Mafia. And they've conceded as much, that article doesn't actually name them as members of the Alex Mafia. But they try to overcome that by saying, oh no, but this would be read with the previous reportage, the August 2022 article. So people would know from that article that we are the Alex Mafia being referred to. Now there's a serious logical problem with that, which I'll come to later. But let's take that for what it is. That's not what the interdict targets. So this article doesn't help them with the interdict, because this article doesn't name them as members of the Alex Mafia. The interdict is to ban us from naming them as members of the Alex Mafia. So the first article doesn't help them because it's about other words. The second article doesn't help them because it doesn't do anything the interdict complains about. The interdict seeks to ban. Then there's the third article, the podcast, rather. Now what the podcast actually says that they complain about. Now this is on page 01-29 of the founding affidavit, paragraph 62.
Wait a minute, you're too fast.
Apologies, my lady.
So this is the podcast, and now I'm at...
We're on 01-29 of the papers. Now
Yes.
what they complain about, again, is in paragraph 63, they complain about the following words. It's problematic that he, being Mashatile, is surrounded by individuals getting government contracts. In paragraph 64, they complain about the words dodgy people. Now that's not targeted by the interdict. The last phrase I quoted is also not targeted by the interdict. They haven't pleaded here that the term Alex Mafia used on its own is defamatory. It's the other words that they complain about. Then we have what they call News24's publication of the podcast on 3 July 2023. That's on the following page, paragraph 65. And it's this that they say actually spurred them to act. Because here we find in paragraph 65 the words controversial tenderpreneurs. In paragraph 66, mafia mobs, corrupt business practices, and gang. None of those words are targeted by the interdict. So if they win, we can still call them, if in fact that's what the podcast was doing, call them controversial tenderpreneurs, call them members of mafia mobs, corrupt business practices, a gang, but it's the term Alex Mafia that they want to expunge. But on their own version, it's not defamatory on its own. It relies on these crutches. It relies on this scaffolding of offensive language in order to become defamatory. And it's not a question of reading it in context to find its meaning. This is where you can't target a particular arrangement of letters and say this on its own is haram, this can never be repeated, when it only stings you when it's used in conjunction with other words, and you don't seek to ban those words. Now, further on the page is the next publication they complain about, which is News24's webinar invitation of 5 July 2023. They complain in 67.1, tenderpreneurs who bankrolled Mr. Mashatile for years. Not hit by the interdict. Intricate web, not hit. Notorious gang, not hit. A well-known network of corrupt actors who have captured the deputy president. Now that's not a quote from the invitation, that's what they say the invitation conveys as a message. Is that they are a well-known network of corrupt actors who've captured the deputy president. Again, they haven't properly pleaded, let alone proved, and I'll come to the proof, that the words Alex Mafia, which is what, 9 letters, that those words carry all of this loaded meaning. Now, the final point is the Spies opinion piece, that's on page 31, paragraph 71. They say that this piece contains allegations of unlawful conduct, including dishonesty, racketeering, and corruption. They say those allegations, although they're not directed at them, they remain in the picture because they were named at the beginning of the piece. But again, those are not allegations. They're not seeking an interdict that News24 and Network 24 and the journalists must not accuse them of unlawful conduct, including dishonesty, racketeering, and corruption. And they say we're placed at the very core of what is alleged to be a mafia state. Again, not hit by the interdict. So the reason why, now they've backed themselves into a corner, the applicants, because in order to come home on urgency, as my leader has said, they had to sacrifice the merits. Because they had to say that, oh no, it only started stinging in June and July because of the additional words. So if the additional words are the cause of the harm, the cause of the hurt, the cause of the defamation, then the term that they're targeting, which comes from 2007, is not in fact defamatory on its own. The second issue for them is that they're bound to the meaning that they allege. So it's not enough for them that it can be defamatory. They've pleaded a particular loaded meaning. In their heads of argument, they do it for the first time. It's not clear, in fact, from the founding affidavit what meaning they attribute to the term mafia state, because they talk about a range of unproven and unsubstantiated allegations. And they use various different imputations from those unidentified statements. But in their heads of argument, they pin themselves to a particular pleaded meaning. They say at paragraph 27 of their heads of argument that Alex Mafia means a group of Mr. Mashatile's closest friends who have scratched his back while he has scratched theirs. They owe their success to him and could not have achieved that success but for their corrupt and nepotistic ways. Now that's quite a mouthful. It's an enormous stretch to say that these two words contain all of that meaning, that they could not have achieved their success without corrupt and nepotistic ways. That's not what Alex Mafia means. Now, it's a question. What the meaning is a question of probability. Now, their stretched meaning that they've now attached to it, and they're bound to that, is not probable at all. It's certainly not more probable than the non-defamatory meaning that we contend for, which is a close-knit group of friends from Alex who were influential in politics and business. Or in the words of Mr. Mashatile, that this refers to a group of activists from the township who later went, from the 80s, who later went into business and government. That's what he says it means. So it's a question of probability. Is his meaning, is our meaning more probable than theirs? We say overwhelmingly yes. So even if we were engaged in that exercise of weighing the probabilities, they would lose. But that is what you do in an action. In fact, our task is much easier. So in an action, we say we would win on the probable meaning, that the non-defamatory meaning, even if the probabilities are even, they lose because they bear the onus of proof. That's LaRue versus Day, paragraph 91B. But this isn't an action, it's an application. So the court needs to be satisfied that, quote from Heilbron versus Blichnote, it is clear that the respondents have, and quote again, no defense. It has to be clear that there is no defense. That's pages 168 to 169 of Heilbron versus Blichnote. It's on page 4-92 of our heads of argument. Now, the way that's been interpreted by the Supreme Court of Appeal is that all we have to do is show that there's a sustainable foundation for a defense. We don't have to prove our defense. Now, based on the evidence we have adduced in the limited time available to us, a trial court could find that our meaning, which is the same as Mr. Mashatile's meaning, is just as probable as their meaning. We don't have to show that a trial court would find that. We don't have to ask this court to find that. We just have to show that a trial court could find that our meaning is just as probable as their meaning. And that's enough. So the application fails at the first hurdle. Now, even if it were defamatory, it's protected comment. Now, we're talking about this phrase on its own, Alex Mafia. That's what we are called upon to defend. That's what the interdict targets. Now that is based on facts that are true. If I may take my lady to our heads of argument, page 04-104. I won't take too long on this.
Paragraph?
Paragraph 56 in the bottom half of the page. We say that there are undisputed facts that provide a reasonable basis for an honestly held opinion that the applicants were engaged in the behavior of a criminal syndicate. So that's saying even if we take mafia literally to mean an Italian, or in this case, Alexandrian criminal syndicate, it's protected comment. And we say so both based on undisputed facts. So the first is 56.1. Mr. Mashatile and the applicants have been close friends for many years. Now, there's nothing wrong with that. Obviously, you can't base an opinion of or a comment of cronyism based on that. But the problem comes when friends go into business together and go into government together and let those two streams of endeavor intertwine in the form of lucrative government contracts. So 56.2 on the next page, we say, this is all reference to the papers, and I don't understand it to have been disputed in oral argument that we've correctly characterized the papers, is that Mr. Mashatile was MEC for housing, the applicant served in his administration. He moves to finance, the applicants follow him, and that's in 2004. So there's one thing I must point out, which is that the first applicant claims early on in his founding affidavit that he left the public sector in 2000. Now that can't be true, because we know, and it's not disputed, that he was serving in the Department of Finance, the MEC, the Gauteng Enterprise Development Agency, after 2004. Nothing greatly turns on it, but it demonstrates this attempt to distance themselves from something that's really quite significant. Dealing with massive sums of provincial money is not a little thing. It's not something that even 16 years later we shouldn't be allowed to talk about. So now, at the same time that they occupy these senior positions in Gauteng Enterprise Development Agency for Mr. Sithole and the Gauteng Shared Services Center for Mr. Maile, they are appointed into these leadership positions, if we're talking about scratching the back. Next, they form an investment company together. They also hold shares together with Mr. Mashatile, or share options in his case, in at least two other companies. That's Gadlex and Moana Investments. There's another scratch. They say to Mr. Mashatile, come invest in our businesses. Then 56.5. In June 2005, the GSSC, headed by Mr. Maile, awarded two major tenders to Business Connection, in which Gadlex owned a substantial stake. So that's two scratches there for two tenders. In May 2007, the GSSC awarded another tender to Business Connection, another scratch. In 2006, cordless security cameras, in which Mr. Maile and Mr. Sithole were shareholders and directors, was awarded a tender by the GEDA, of which Mr. Sithole was the head. Scratch. And a second tender by another agency under Mr. Mashatile's authority or in his portfolio, in both cases without following a tender process. Scratch. So the facts are, this is now not a comment, the facts are that the applicants were profiting from contracts awarded by the Gauteng government, in which they held leadership positions at the time, and in which their close personal, political, and business associate, Mr. Mashatile, was the MEC in charge of the agencies awarding the contracts. Those are the facts. Now, what comment can one make on those facts? Now, first, the question is, what exactly is the test? Now, the test is not, as Mr. Berger indicated, whether the view, the opinion is honestly held by the defendant or the respondent, or Mr. Basson as the deponent in this case. That would be a mens rea issue, not a wrongfulness issue. You look at the term on its face, objectively, whoever said it, doesn't matter. It's the context and the content of the statement to determine wrongfulness. So mens rea is a separate inquiry. At the level of wrongfulness, which is what protected comment rebuts, The opinion has to be held, it's to quote from McBride, Citizen versus McBride in paragraph 81, the test from Crawford versus Albu is an opinion that a fair person, however extreme, might honestly hold. So a fair person, any fair person, the hypothetical person, might honestly hold, even if the views are extravagant, exaggerated, and prejudiced. And of course it has to be based on facts that are true, and it has to be on a topic of public interest. We've explained the facts, the true facts on which it's based. Now, the publication doesn't itself have to be in the public interest. Now, our learned friends seem to be mistaken in their apprehension of what that leg of the test is in fair comment, in protected comment. It's not like in defending a statement of fact that it has to be true and in the public interest, that there must be some need, some public need to bring those facts to light. This is a case where a comment can be expressed on a topic of public interest. Now, Mr. Mashatile, so the characterization that there's no need to refer to the applicants, there's no need to name them, the public interest doesn't demand it, the public interest doesn't require it, these are the words that have been used. That's not what protected comment is about. Protected comment is about the marketplace of ideas. It's about allowing people to speak robustly about topics that are of public interest, in which they may name people in unfavorable terms, but as long as it has a relationship to true facts, and it's can be unjust, extreme, exaggerated, and prejudiced, it's protected. Now, Mr. Mashatile's past scandals are indeed a legitimate topic of public interest. McBride, as my leader has said, is against them, where you can rake up the past when it's about a person's suitability for office today. That's obviously the topic of the articles. The headlines make that clear. And to mention his past is to mention who was involved in that past. These were the business links that were questionable. The people that he was in business with, the people who were his closest friends, were profiting from contracts under his portfolio. We have to name them. It's part of the historical record. But even if we didn't have to name them, we're entitled to name them. Now, it's not even their case, because now they say, no, we're not complaining about the allegations about the tenders. It's just the term Alex Mafia. But Alex Mafia is a comment on the tenders, if it's defamatory at all. It's a comment that those tenders were mafia-esque. If that is the meaning that the court finds more probable, then it's protected to say that those contracts were, that behavior, that incest between government and business was mafia-esque. Now again, we don't have to show this on a balance of probabilities in this motion court. We'll do that in the trial court. Today, all we need to do is lay a sustainable foundation for a defense, which we have done. The applicants cannot say that on the papers we have no defense. So the application falls at the second hurdle as well. There's a final point I'll make just to add to the balance of convenience, which is that the interdict would be ineffective for the reasons that my leader has already said. But also, where applicants' counsel contends that even where they're not named, they're somehow identifiable because of the prior publications. Here is the logical self-destruction that I alluded to earlier. You can't say that the 26 June article is actionable, even though it doesn't name us. Because you name Alex Mafia and people know it's us because of the previous publications. But then you say, oh no, we want an interdict saying that you can use Alex Mafia as much as you want, as long as you don't name us. But you've said in your argument and in your affidavit that people know it's us anyway. So then we are identifying you, if we just say Alex Mafia and leave out your names. So the case can't work. It can't make sense. And that's because of the 16 years that have passed. It's a self-created conundrum for the applicants. And unfortunately, the interdict they're seeking can't actually extricate them from it. because if we mention Alex Mafia, they say people will know it's us anyway. And that's what they want to allow us to do under the narrow ban that they claim they're seeking. Now, what it does do, which is which is more than a minor inconvenience. It's been classified as a minor inconvenience by the applicants. It's not. It bans us from quoting politicians or political commentators who refer to the applicants as mafia. It bans us from allowing columnists to refer to them like Mr. Spies did. And that is not merely a minor inconvenience. It's a serious restriction on free speech, which will endure for several years. But when we do so, on their own version now, they will still suffer the harm. That even if we mention Alex Mafia without their names, they now say they're going to suffer harm. So the balance of convenience can never favor them on the facts that they've put up. So the interdict we submit can't be granted on any of the bases. My learned friend has spoken correctly about the sliding scale between prospects and balance of convenience. They fail on both. If the balance of convenience was with them but the prospects were weak, they might lose. The prospects are weak and the balance of convenience is against them. They have to lose on both counts. My lady, if there are no questions, then those are our submissions.
Thank you. Mr. Burger, in reply.
Thank you, lady. I'm not sure if they want to move.
Not inviting coverage, but thanks. Maybe, my lady, if I can just start, this has just reminded me. We don't object, or it'd be too late to object now to the News24 coverage of these proceedings, but it would have been nice had we been given the heads up that this is what would be happening in court today. First time we were aware of it was when we arrived and these microphones were put in front of us. So just as a common courtesy, it would have been appreciated if the respondents had alerted us to that. If I can then deal with a number of points that have been raised.
Do you want me to say something about this?
No.
Or you're just placing it on record?
I'm placing it on record. It's up to you. I believe that the issue was brought to your attention, but certainly it was not to ours.
I assumed it was. I mean, I assumed that, and your failure to say anything, I mean, I just assumed...
No, it wasn't brought to our attention.
All right, but it's unusual to wait until the conclusion of a hearing. At the end of the day, it's now 4 o'clock.
No, I'm not objecting to it. I'm just
and
placing
now we deal with this point.
I'm just placing it on record. I should have raised it earlier. We're not objecting.
I'm not sure what you want me to do about it. So you're not objecting, so why are you saying anything about it? So they were discourteous to you, and the court was discourteous, or...
No, I'm not saying the court was discourteous.
So your point about it is?
And you can deal with it as you wish. If you choose to ignore it, that is also fine.
All right. I'm not sure what you want me to do about it, but I'm just recording it.
I withdraw the comment then, my lady.
All right.
I withdraw the comment. If I can then start with the point as to we should have come earlier. We should have come, it's the point about that Mr. Du Plessis made about our so-called 11-month problem. And that we, even on our best case scenario for us, we ought to have come in August of 2022. But at that stage, we had no reason to believe that there was going to be a repeated publication of the story. There wasn't any further publication by News24. There was the one article by them, there was the second article just before the conference in December, and then fast forward to after Mr. Mashatile. Then
Mr. Du Plessis' point in this, if I understood him correctly, was that you had every reason to anticipate more coverage by virtue of the activity of Mr. Mashatile at that point in respect of the ANC generally, and then, so he said that should have alerted your clients that things are now going to escalate.
My lady, if we had come to court at that time seeking an urgent interdict, or even an interdict, whether interim or final, we would not have been able to make out any case as to our reasonable fear of irreparable harm. We wouldn't have been able to do it. That's the simple point I wish to make about that. The point is then made, the reference to paragraphs 62 and 63 of the answering affidavit, where relying on the confidential source, the allegation is made that we call ourselves the Alex Mafia. We deal with that in reply at 70 and 71, and the point we make is that that evidence is not properly before this court. And if we are correct that that evidence is not properly before this court because it's hearsay evidence, then that's the end of that matter. We also do make the point up front in paragraph 4 that we don't deal with we cannot simply deal with every allegation. And part of the reason why we simply cannot do that is that we had very little time to do the reply. We had hoped to get the papers by we had said in our notice of motion by close of business on the Monday, and we got them, I think, at around 9:25 on Tuesday evening. And if we were to be in court on the 1st of August, and good reason why we couldn't delay it further, we had a day. And so with a lot of information to deal with, it's understandable that things get done quite rushed. And
what do you say about Mr. Du Plessis' point that you could have done the obvious thing and just deny it if that is the version, but instead you raised the hearsay point, having brought an application urgently, and you know that the rules of evidence are flexible in urgent court, so just deal with the allegation head on, even if it is found in the end that it's hearsay, but then at least you've dealt with it. Why? Because it's a one-liner. Either it is so, or it isn't so, and he's asking that your failure to deal with it should carry some weight. In fact, it should be construed as an admission.
I think it's quite, again, in urgent proceedings, in trying not to, at the reply stage, understanding often that the little that a reply may do, a simple denial at a reply stage doesn't necessarily assist the court. There isn't evidence that's properly before the court. It doesn't take it anywhere. There's no indication anywhere in our papers that we refer to each other as this. The only thing that they can rely on is that claim, and then the allegation they rely on is the article, it's Annexure AB 22 to the answering affidavit, the financial Maile article about what Mr. Mashatile himself says. And my lady, if I can take you to that. That is at page 01-284 of the papers. And Mr. Mashatile doesn't mention us by name. What he does in that article, he says, and in fact, again, similar to the Rebecca Davis article, where your ladyship mentioned that it wasn't a quote, it was simply a report. Similarly, this is a report where he says as follows. He's nicknamed the Don of the Alex Mafia, though he's quick to explain that the term simply refers to a group of 1980s comrades from the township who went on to serve in government. The name harks back to the 1960s when it was used for a group of leaders that included Umkhonto weSizwe's Joe Modise and Josiah Jele, as well as Thomas Nkobe and Joan Plantler. And then this is the quote from Mr. Mashatile. It is political, there is nothing illegal about it, he says with a laugh. But there's no quote from him about us, and he doesn't mention us by name. I stand by everything he said earlier in relation to what this court should read into that when others have understood the term to mean something different, including Mr. Mashatile's political superior at the time, the then Premier Shilowa. There was some attention placed to what we say at paragraph 14 of the founding papers, the reference to at the core of this application. If I can just read the paragraph as a whole.
Sorry, where are you reading from now?
Paragraph 14 of the founding affidavit, 01-11. Where we say as follows: at its core, this application seeks to interdict the 1st to 7th respondents from repeating unsubstantiated and unproven allegations about Mr. Maile and me, and this is the important part, that identify us as core members of the so-called Alex Mafia. So it's correct that we say at the core it's about repeating unsubstantiated and unproven allegations, but these are allegations that identify us as core members of the Alex Mafia, and the allegations in question are not allegations from 2007, but we say these allegations are contained in the following publications, and then we list the publications starting with the August 22 article onwards. So just to clarify how that comment is made. Then getting to the issue of fatal flaws, simple point I wish to make is that, and this is in the context of the focus on pre-publication bans, and that is that an application for interdictory relief is going to be about publishing in the future. That's why you're in court. You're saying stop publishing these defamatory allegations, stop doing this, whether it's in the context of remove an article so that you don't continue to defame us, as was the case with UDM versus Labashe, and I want to come back to that, and in particular the Constitutional Court judgment in that, or it's in our case, you've already published X, Y, and Z, you've told us you're going to continue publishing the same stuff, stop publishing the same stuff. We say that it's in that context, which is substantively different from the type of interdict where you're trying to stop publication of a book for the first time, for example. You're trying to prevent information from getting into the public domain. We're saying stop repeating it. So it's, in substance, quite different. Then the issue of non-joinder, which even though we have abandoned and we sought by way of amendment to dispose of Pre 2.2, we don't understand what legal interest the M&G or Stefans Brummer would have in the relief that was sought in Pre 2.2. We're not seeking to interdict them from doing anything. We're not seeking to stop the M&G from doing anything. There's no, if granted, that order would not place any obligations on them. What we're saying, what the interdict sought was to prevent News24, who is the only media house that has this special project on the Deputy President, as part of their coverage, not to say what we have had issues about. We deal with this in the replying affidavit at paragraphs 44 and 45.
So just before you go to the reply, perhaps we can also go to the reply of paragraph 17 of the founding papers, because there the allegations made, the impugned allegations have their origins in an article published by Mr. Basson on 31 August titled X, published by the Maile and Guardian. And that's the point that Mr. Du Plessis made. Is there it's exposed that this is this is where the impugned allegations were born, and Mr. Basson and the co-author,
Mr. Brummer,
wrote it, and the employer at the time was Mail and Guardian. So
Correct.
clearly they ought to have been joined.
For what purpose, my lady, we ask? We don't know what. We're not seeking any relief against them. We're not seeking to stop them from doing anything. We make it clear, and obviously we couldn't sue for defamation based on a 2007 article in 2023. But there's no relief anywhere that's contemplated against the M&G or against Mr. Brummer. Mr. Basson has been cited not because he's the author of that, but in his capacity, we say, as the editor-in-chief of News24. That's why he's here, not because of the original article. We simply refer to that article, well, for two reasons. One, because it's Mr. Basson who proudly proclaims his role in 2007 in his reportage, together with Mr. Brummer. And secondly, the article in August of 2022 directly refers to that article, and there's a hyperlink to that article. So it's because they brought it in 2022 that we then consider that article.
All right, so you were going to go to the replying affidavit.
It was just the two references in paragraphs 44 and 45 of the reply where we deal with the issue of non-joinder.
44 and 45.
5 of the replying affidavit. Then on the issue of 2 days to answer, the application was delivered on the Tuesday. They answered on the Tuesday. They essentially took 5 full days to answer. We had given them 4. They took 5 full days to answer. These court days, that is.
So it was delivered on Tuesday the 24th?
No, I think it was Tuesday the 14th of July. Sorry, no. No, there isn't a Tuesday the 14th. Tuesday the 18th, sorry. It's signed, the notice of motion is signed the 17th, but it was delivered in the early hours of Tuesday the 18th, and then formally filed on the 18th, the Tuesday. And they were then given, it's correct that they were given 2 days to deliver a notice of motion, and then a
notice
further
of intention to oppose.
Sorry, a notice of intention to oppose, and a further 2 days thereafter they answer. But in an urgent application, you don't sit on your hands for the first 2 days, waiting to see. And the point that Mr. Du Plessis raised was that they needed the 2 days to consult and to take instructions on whether to oppose. But if one goes to have a look at Annexure FA12, which is it's our letter, the Annexure FA12, where this is our second letter of demand. So there was the initial letter of demand, there was the response, we came back, we then, and we say in paragraph 10 of that, should an adequate response not be forthcoming, our clients will approach the High Court early next week for urgent interdictory relief pending the outcome of the contemplated action for damages. So on the 10th of July, we tell them, this would be on the Monday, we say if we don't get an adequate response from you by close of business this Friday, we're going to bring urgent proceedings next week, and we do. We bring them on the Tuesday.
Sorry, just go to that letter. It's at, where is it on case lines?
Annexure FA 12 01-106.
And
it's paragraph 10 of that letter where we say and this is in a letter on the 10th of July, we say if we don't get an adequate response by Friday, we're going to be filing papers for an urgent interdict next week. The response to that I think the response is dated the 14th of July. I'm sorry, I don't have the annexure number. FA 15 01-119. That's the response from Mr. de Klerk on behalf of News24. And I wish to take you to the last part of paragraph 8. This is on page 3 of the letter, where they make reference to that and say, we advise you that should you elect to embark on ill-advised urgent motion proceedings, we reserve the right to disclose this letter to the court and seek an appropriate cost remedy. We attached that letter to our founding papers. This was a letter that we received on the Friday, the 14th, when we had said we wanted a response. So we said to them, if you don't give us what we want by Friday, we're going to court next week. On Friday, they say, we're not prepared to give you what you want. And if you do embark on these proceedings, we'll bring it to the court's attention. So then, it's a long way of getting to the point that to say, when you receive the papers on Tuesday, I think it's somewhat disingenuous to say we needed the 2 days to decide whether or not to oppose, and we only had 2 days to draft an answer. They didn't. They had 5 court days and an intervening weekend. What they also had time to do, and not the attorneys, but News24, was they also had time to publish on this in a number of ways. So they certainly they were alive to what the issues were, and the idea that they only had 2 days to put an answer together, I think, is ludicrous. The next point is the issue about the so-called Streisand effect, and your ladyship will be aware that there is a tweet. Mr. Masondo, someone drew that to his attention in a tweet when they published their first article about the case, and then he mentioned that he had to Google it to see what it means. So it's clearly in the papers, this issue of the so-called Streisand effect, which, if memory serves me correct, is something you dealt with in your judgment. But with respect to it, every person who brings a defamation claim knows that by bringing your claim, you open yourself up to further scrutiny. By the time your case gets to court, the public may well have forgotten. 3 years later, suddenly you're back, and everyone's aware of that. But that cannot be a basis for saying, essentially, for stopping you from asserting your rights. What happened in this case was that there hasn't been, certainly nothing on the papers to suggest that there's been, and that I'm aware of, that there's been widespread media reporting. There's been a lot of reporting, and that's been reporting by News24 and amplifying of the reporting through Twitter and media such as that. And then, well, it's not in the paper, so I won't go there. But the reason why there has been the so-called Streisand effect is because News24 has taken full advantage of this case to report on this case.
If I remember correctly, in that case, the publication was something like to 30,000 or maybe even less readers initially, but because the applicant had 1 million Instagram followers, she had published it on there. So there was clear evidence that her publication had, and I think it's in the judgment, had exacerbated the publication. her own conduct.
Yes, and
So your point is you can't blame somebody for coming to court.
when there've been repeated publications.
Yes.
And I think in the Streisand case, if I remember correctly, it
No,
was.
no, I'm talking about the Maboti
Okay.
case.
Sorry.
That
No, I'm
case
saying
that-
where it actually comes from.
I
that-
know that you're talking about that, but I'm talking about
Yes.
the facts in the case in which I found that.
I can't take that any further, my lady. My lady, the next issue I wish to touch on was the point that Mr. Duplessis made about the fact that we don't deal with all the case law on prior restraint, and he then proceeded to take you through all that. What I find quite significant is that there's one particular case that they don't deal with, and that is the UDM versus Lebashe case in the Constitutional Court, which is quite damaging to their case. So where they deal with it is they deal with a passage from the dissent in the SCA, and correctly they say that's a point that the majority in the SCA didn't deal with, because the majority in the SCA found that leave to appeal ought not to have been granted and dismissed or struck it on that basis. The matter then went up to the Constitutional Court, and the interim interdict was upheld. And so whatever Her Ladyship Justice Maile, now the President of the SCA may have said in Lebashe, really must be understood in the context of a unanimous Constitutional Court upholding the interdict that was granted originally by the High Court. It was an interdict granted in 2018. It got to the Constitutional Court towards the end of 21. No, sorry, I think it was May. Was it May 21? It was argued, or judgment was quite late. So it took a number of years, and as far as I know, that matter still the trial hasn't proceeded. But that was an application for an interim interdict on something that had been published widely. What they sought was for the article to be removed, because the allegation was made that keeping the publication online is effectively continuing to publish day after day after day. And interestingly, it wasn't brought by the media, but it was brought by a political party. A political party of two, but nevertheless still a political party in the National Assembly. And this is what Acting Justice Madondo says at paragraph 2 of that Constitutional Court judgment. This application has its origin in an interim interdict granted by the High Court against the applicants on 16 July 2018, pending a defamation action that was to be instituted by the respondents against the applicants. The applicants complain that such order has since restrained and prohibited them from exercising their right to freedom of expression and from performing their duties as political actors in terms of the Constitution. So, not a media house, but they're saying we have different obligations, and one could argue equally important obligations as opposition members of Parliament to be able to play our role as political actors. And you're stopping us from doing so by interdicting us. Nevertheless, the interdict was upheld by the Constitutional Court. Interestingly, in that case as well, the allegation was made that because it's going to take so long, and in fact it did take so long, it would be final in effect, and yet that argument fell flat in the Constitutional Court. Just on the deadlines, it was argued on the 2nd of November 2021 in the Constitutional Court, judgment on the 22nd of September 2022, some 4 years after the initial interdict, and that was the ultimately the application for leave to appeal against the High Court order. But I do find it interesting that judgment is completely ignored by the respondents. On the issue of semi-urgency, I just wish to make a single point, and that is that a matter heard on a semi-urgent roll is still on the urgent role. The time frames would be much more generous, but it is still an urgent role, and it doesn't address, it doesn't take away the concerns that ordinarily arise in urgence. It's still, urgency still has to be established.
The degrees of urgency.
Degrees of urgency, yes, but still urgency. It's still being heard in terms of 612A and not in the ordinary course. Mr. du Plessis mentioned that, well, alleged that we didn't complain about the use of the term captured agencies in Mr. Basson's article of August 2022, but the reference there that I wish to draw your attention to, I won't go there now, but it's paragraphs 54.2 and 54.3 of the founding affidavit when we are describing that article, and we draw particular attention to our concerns with the use of that term, captured agencies, captured agency.
52.1 and...
Sorry, 54.2 and 54.3 of the founding affidavit. That's at page 01-26 of the papers.
Thank you, Ms. Wilson.
I'm also indebted to her, my lady. An interesting comment was made about the use of the word notorious and the phrase notorious RBG. I think it's quite different, the context in which that was used as one of relying on a rap song to refer to a 80-something-year-old justice of the US Supreme Court was done almost as a term of endearment. The word notorious, when used as part of notorious Alex Mafia gang on an advert that is talking about looking at allegations of corruption and nepotism, clearly cannot carry the same meaning as that. If you're a member of the notorious Alex Mafia gang, that makes you a notorious gangster. And it's not gangster in the sense that young kids might use it in an affirming sense. It's said gangster in the context of a Rashid Stahi kind of gangster. On the issue of the press ombud, the only additional point I wish to make here is that Mr. du Plessis argued that as part of his argument on urgency, and yet the reliance on the press ombud was dealt with both in answer and in their heads in dealing with the final leg of the application for an interim interdict. And so they haven't, certainly not on their pleaded case, isn't that was a basis not to, that we ought to have dealt with it in dealing with urgency. The court raised that, but they certainly did not raise that. It is correct that in our initial demand we sought a retraction, but when it became clear that our appropriate course of action was to apply for urgent interim relief, obviously we couldn't. We chose not to. We couldn't pursue that. On the issue, again, of misjoinder and the original Prayer 2.2, even if the respondents are correct on the issues of misjoinder, and even if they are correct that we ought not to have sought the relief we did in the initial paragraph 2.2, that doesn't on its own provide sufficient reason for the entire application to be dismissed. If they are correct, then it may have provided reason to not to grant the relief sought in paragraph 2.2, but one cannot rely on a misjoinder of a party who has no interest in anything else in the application that's granted. So at best for them, it would have been a basis for not granting the relief in paragraph 2.2, not for dismissing the application as a whole. On the issue of what this court is to do in relation to that issue, Mr. Duplessis was pushing for this court to write a judgment on those issues. And the only point I wish to make here is that courts don't give advisory opinions, and if there is no live dispute between the parties, then that should be the end of the matter. If, as we say, we've abandoned that relief, there really is no purpose served by this court considering the relief. Obviously, this court would be well within this court's right to deal with the manner in which the amendment was sought, and to recount how it was sought if this court has any problems with it. But it wouldn't be a basis for this court reaching any finding as to whether the relief sought in 2.2 could ever have been granted. That would constitute an advisory opinion that we say this court shouldn't get involved in. The reference to the Karen Moore judgment in her matter dealing with the former president's private prosecution is quite interesting, but I think it's in substance fundamentally different from a case like this. A very powerful individual, seemingly with resources at his disposal, plenty of resources, brings a private prosecution against an individual. Luckily for her, she was able to receive the support, I understand, of her employer. But even with all the support, if that prosecution had gone ahead and had there been any possibility of a conviction in that prosecution, which was brought for an ulterior purpose, she would have been facing the possibility of a criminal conviction. In substance, very different from two individuals bringing an application such as this against a media house with seemingly deep pockets. I think in substance, very different issues we're talking about. I hope I wasn't misunderstood, but I don't remember having said in my original address that the motivation for bringing this case was that others would be on their guard. I think I made the express point that us making the point that any order of this court will obviously have implications for others. How that got elevated to an admission on our part that this was the motivation for bringing this case, I don't know, but it certainly, no such admission was made. The issue, much of what Mr. Winks said about where he went through the various articles, looking at the individual, the use of the words, and that the relief we seek is about the words Alex Mafia. But the reason why we focus on that, it's not, we haven't abandoned the point that we believe that those words per se are defamatory. But our case has been primarily based on how those words have been used by Media24, and in particular how those words have been used since the end of June 26, from June 26 onwards, and how the words used in context. And it's the fear of how those words will be used in future in the context that what worries us. The articles that have been written and the articles that we are concerned about are articles, as we said earlier, that are not about us. And so, if they're not about us, then there would be no reason to mention us and to identify us as part of this gang, or this mob, that is alleged to have captured the state. And so it's how the words are used in context is how they ought to be interpreted, not words out of context. Out of context takes you back into the realm of dictionary definitions.
What do you say about Mr. Winks's criticism that you argue that everybody knows who you are referring to if you speak about the Alex, if one speaks about the Alex Mafia. But in the same, and they're not allowed to say, or the interdict is directed, or you could say, you can speak about the Alex Mafia, but you're not allowed to identify the applicants as being party or part of the Alex Mafia. Everybody knows that those are the people who are referred to. Then how is this
going to help?
How is this interdict going to be enforced, and what is the media supposed, or Media24 supposed to do? How, because if they say nothing, then it's implicit that everybody knows, and therefore they've breached the agreement, the order. If I grant the order, they've breached the order, because it's in contempt, won't they? Then, I mean, they're damned if they do, they're damned if they don't type of situation.
Now, my lady, I think that our understanding is that the argument that you don't need to mention us by name was an argument that was made specifically in relation to a set of articles that were published, or set of publications spanning a few days. And it was in that context where we said, you have a podcast on day one, you mention us by name, the host of the podcast mention us by name and say that we're part of the Alex Mafia. 3 days later, or a week later, you then publish the transcript of that podcast. We mentioned again, maybe the actual entry online, before you click on the actual transcript, doesn't mention us, but we're there in the transcript. And then a day or 2 days, it was the 3rd of July, and then on the 5th of July, you issue a webinar invitation which talks about the notorious Alex Mafia.
Those are the historical facts.
Yes.
But now the question is going forward. Now everybody knows that's your argument. Everybody knows, or everybody, because if you join the dots, you say all these articles implicate the applicants. So now we here today, and the court issues an order. So now, how does it help?
My lady, when there are repeated publications over and over again, and there's a mention of a name the one day, no mention of the name the next day, and it constantly comes back, and it's brought back into the public domain, then people will know. But if the names are no longer mentioned, the public moves very quickly, and when it then gets published again, the reasonable reader would not, if it's published in, let's say, in a month's time, another publication comes out, some readers may well remember it back from then, others will not. Others will be new readers and won't see it. It's the reference to articles in a series, I think it has to be a series over a particular time span. I don't have much left.
Take your time, Mr. Berger. Don't feel rushed.
Okay. Thank you, my lady. Paragraph 54 of our heads, Mr. Winks referred to, where he says that this is our pleaded meaning. This is not the meaning that, this is the meaning that is put out in heads of argument, and essentially it's not a meaning for what the words Alex Mafia mean out of context. It's dealing with an interpretation of the words as used in context in relation to the articles that we're complaining about that will form the subject of the contemplated action. And we're dealing with this as part of our, as we move towards dealing with prima facie right, with the knowledge that one way to establish prima facie right is to speak about prospects of success in the action or the main application. And so it's in that context that in heads of argument, not in an affidavit under oath or not in a plea or anything like that, where we're arguing as to what the meaning of these words as used in context, what it carries with us, and whether or not that is sufficient for us to establish that we have good prospects of success in the action. That's not a pleaded meaning of what Alex Mafia, the words on their own, mean out of context. So just to clarify that. Then, on the point about the honestly held opinion and who has to hold that, I can just take you to it's in the judgment of Citizen versus McBride, which is in the respondent's bundle. And at paragraph 103 of the judgment, Justice Cameron says as follows: as already indicated, it is a requirement in our law that the comment sought to be protected must qualify as an honest, genuine, though possibly exaggerated or prejudiced, expression of opinion relevant to the facts upon which it was based and not disclosing malice. And then in paragraph 105, the question is whether the evidence established, first, that the citizen's view as to Mr. McBride's suitability for appointment was genuinely held, and second, if it was, whether the citizen abused its right to express that view, for malice indicates an absence of right, which makes unlawful that which would otherwise have been lawful. So that goes to who needs to hold that, who needs to have that view, and whether it's an honestly held view.
Yeah, but he draws a distinction between the subjective element of intention and the objective assessment of this defense, the lawfulness of it. So I think
my understanding of those passages from Justice Cameron's judgment is that
the protected
he's talking about that the citizen had to have, it had to be an honestly, if the view expressed by the citizen was genuinely held, then it would be protected comment. And I just referred to those two paragraphs, 103 to 105.
Lawfulness is determined objectively, is that correct? Lawfulness of whether something is, I mean, you've got in a delict.
Well, in defamation, the what's objective is the test for determining whether it's whether it's defamatory or not. The defense we submit in the context of protected comment, relying on these paragraphs, is that opinion needs to be honestly held by the person expressing it. And I can't take it any further than just to rely on those passages. I have two further issues I wish to deal with. The first is the concerns that we have with a number of the judgments on which the respondents rely. I've already spoken about the UDM versus Lebashe judgment. I think Mokate, the judgment of Justice Tolme, must be read subject to what the Constitutional Court said in UDM versus Lebashe. Then there's a reliance on affordable medicines, paragraph 9 of that judgment, dealing with amendments, and there the reference to it in the heads of argument appears to be to support an argument that a submission that an amendment is an indulgence, but really what paragraph 9 of Affordable Medicines is saying is that amendments will ordinarily be granted unless there's good reason not to grant them, unless it's Maile fides or unless there's an injustice to the other side, and that the ultimate test is the interest of justice. We don't make the submission that an amendment is simply there for the taking, but that the court will start from the position that an amendment is ordinarily granted unless there's a good reason not to grant it. Then the Fed Group judgment, that's the judgment about amending where you seek substantially different relief. That is quite distinguishable in a number of ways, including because it was an amendment that was sought on appeal very late in the day. And the amendment that they sought was to result in them seeking relief that they themselves were on record as saying would be ineffective. So that the particular facts of Fed Group, I think, need to be borne in mind when looking at what that case says. The case that wasn't mentioned in an argument but is in the heads of argument, the Heinemann case, a pre-1994 decision of the then appellate division, which was dealing with a ban on a Wilbur Smith book. And I think the point is made that even under apartheid, things weren't as bad as what you guys want to do, because the AD was prepared to accept these arguments, but also that was a dissenting judgment in that case, and details like that ought to be brought to the court's attention. And then there's a reference in the heads also to Rawula, and again, where they deal with a number of cases, and the focus on that case was on comparing bringing a defamation claim for a final interdict and damages by way of application proceedings versus an interim interdict pending action for damages. So the cases that Rawula talks about and the manner in which it's advanced in the heads doesn't recognize that it was brought in that those issues were being discussed in the context of whether you can bring an application for a final interdict, and damages by way of application proceedings, or should you seek interim relief pending an action for damages, which is what we have done here. The final set of issues I wish to deal with are some of the allegations that are made about concessions that the applicants have made. And in particular, in paragraph 5 of the heads of argument, an allegation is made, and it was repeated in argument today, that essentially that we have admitted those allegations and that we have not contested those allegations. And I don't want to take you through it in any detail, but I do want to draw your attention to paragraph 49 of the replying affidavit, where we set out in some detail it's 01-380, where some of the allegations from that original 2007, I think the reply says 2017, that means it should be a reference to 2007, are dealt with. And so, for example, it deals with the issue of Mr. Maile's appointment as CEO of GSSC and how that, who was party to that. It deals with the so-called investment company that was jointly formed in 2005, which, as the reply makes clear, never had a single trade and never even opened a bank account. The way in which it's presented is here's a joint investment company that these guys were running together, when in fact it never did any business. And then in paragraph 49.4, it's a reference to paragraph 12.5 of the answer, where we say much is made of the award of tenders to BCX in the mid-2000s, and the award of those tenders is quite adequately, I submit, contextualized. That the assumption is made in the articles that it was the arrival of Mr. Maile in that position, facilitated by Mr. Mashatile, that gave rise to BCX being awarded contracts, when in fact BCX was already providing services to the state, and it was in the context of the nature of the services that it was providing that the state needed to continue to receive. It was in that context. And so it's incorrect to say that all of these allegations have simply been admitted and nothing has been contradicted. Much of it has been dealt with in reply, and because of the nature of the reply, it says we're not going to deal with everything here. My lady, those are our submissions.
Thank you. In this matter, judgment is reserved. Court will adjourn.
Oh.